Well, good morning.
Morning. Morning.
I am now calling this meeting of the Indiana Recount Commission to order. I am Indiana Secretary of State Diego Morales, Chairman of the Indiana Recount Commission. With me today are Recount Commissioners Michael Claytor and Commissioner Paul Mullen. I will note for the record that 3 Recount Commissioners constitutes a quorum for the Recount Commission. So with everyone present, we have authority to proceed today. I will also note for the record that notice of today's hearings were posted in the Government Center and on the online Recount Commission webpage. Also, parties of the proceeding were served with notices of today's hearing. As usual, I would like to start the meeting with saying the Pledge of Allegiance. So if everyone can stand with me, please.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, and you may be seated. With us for today's hearing is Attorney Evan Norris, a Recount Director, Attorney Matthew Kochiver and Kegan Prentice, serving as legal counsel to the Recount Commission. Also representatives of the Indiana State Board of Accounts, State Examiner Paul Joyce, Chief Auditor Jennifer Gauger, and Board of Accounts General Counsel Matthew Black. Also, Stewart and Richardson Court Reporter. Thank you for being here. On today's agenda, we are proceeding with Indiana's 2026 primary election, Senate District 23 recount. Based on Recount Commission Order 2026-34, the Commission will receive updates and reports from Recount Director Norris. Then we will hear from counsel for petitioners, from petitioner Paula Copenhagen and her counsel for respondent from Mr. Spencer Deary. Following the opening statements, the Commission will proceed with county by county, precinct by precinct ballot challenges, which will be led by Recount Director Norris. Before we begin, opening statements and deliberative process, I will request that any candidate in this contest and any witness or state officials who may be testifying today, please stand and be sworn in. Please raise your right hand and respond with "I do" after I read the following statement. I do solemnly swear under penalties of perjury that the testimony you may give today is the truth and nothing other than the truth. So help me God.
I do.
Thank you. Please be seated. At this time, I would like to ask Mr. Norris so he may proceed. Mr. Norris.
Thank you, Mr. Secretary, members of the Commission. Again, Evan Norris, Recount Director. I'm going to walk us through this morning the process since we are here for the final hearing, a little bit of a nuanced type hearing. So we are going to go through this as systematically and methodically as possible so that SBOA as well as Deputy Directors Kraft and Plopper can keep track as we go along. Today's roadmap will consist of the following. First, we have done the call to order. Next, I will do my update. Third, we will go to the report on filed statements, which are our Section 20B6 Commission will then act upon those, and I can explain more of that in a second. Then we'll go into opening statements, then the ballot presentation, then the director's final report, and then at the end of today, we'll adjust, resolve, and certify the results. The call to order has already taken place. In the director's update, I will briefly touch on Tippecanoe County Wabash 4, which I omitted from the last hearing that we were at. And then under section 20B6, again, we're going to go through these statements, these written statements, which I will present copies to you here in a little bit with regard to the ballots that the candidates are no longer challenging as of, I believe, Friday and Saturday this past weekend. And I will go through that. And that's another process, commissioners, that is contemplated under the guidelines. So we just need to cross that box off. After that, we will do 15-minute opening statements per side if necessary. Petitioner Copenhaver requested 15 minutes, so both parties will have 15 minutes to present any openings if they so choose. To discuss how the ballot presentation is going to go. So the county order, we're going to start with Montgomery County, and then the guidelines state that we shall go precinct by precinct within the disputed ballots or within the disputed counties. For example, Montgomery County has one precinct, and that's Coal Creek precinct, that's being challenged today, or excuse me, 3 precincts that are being challenged. The one that's not being challenged is Coal Creek. So we will go through alphanumerically the precincts for each county and moving through this list, hopefully being able to, conduce or be a little more concise as we go through with the understanding of the parties' arguments. Kind of when we're in the precincts, we'll do this. So the petitioner will present each disputed ballot one by one, identified by the SBOA exhibit number. I will permit the respondent, he will have an opportunity to respond to each ballot as it is presented. And then after that, we will ask that the commission make a determination on each ballot as presented. And then the respondent will have an opportunity to present his objections as well. Once all of the precincts, all of the disputes in a particular precinct have been adjudicated, then we will move on to the next precinct, to the next county, so that we're doing this in a systematic and formulaic manner. At the end, I will notify you if there are any disputed ballots that the parties have not presented and present those for final adjudication. And then at the end, we will adjust the tally, resolve any other issues, including one thing that I've omitted from this particular screen is we need to lift the impounds prior to the end of today. So if one of the deputy directors will remind me to make a motion to lift the impounds, that would be great. And then at the end, we will certify the results. Reminders for council up here very quickly. Again, because there are so many disputed ballots, you need to remember that every ballot needs to be identified by SBOA exhibit number. We will only be discussing one ballot at a time, and the commission will rule on individual ballots as presented. The parties are responsible for grouping their exhibits and ballots by precinct. All testimony given here today shall be sworn, which we've already gone through. The number one thing that I want to remind the parties of is voter privacy is protected. So any materials identifying any individual voter shall not be placed on the screen or in the public domain without first discussing with us and having that sort of conversation off the record. I just don't want to have any situation where any voter can be identified through any of the ballot materials. So we will ensure that all ballot secrecy is maintained. And then at the end, again, the commission will make all final decision on whether a disputed ballot is counted. Commissioners, going into segment 2 very quickly, the recount director's update. The only update I have for you at this time is that I omitted Wabash 4, Tippecanoe County from the list of those precincts that were not in dispute. You can see here that in Wabash 4, we had no disputed ballots. At this time, I would offer a proposed motion that with regard to Tippecanoe County, that the commission move to accept the recount director's report and that you count the ballots cast for each candidate, not count any undisputed invalid ballots, and not count any undervotes in the Wabash 4 precinct.
Mr. Chairman, I would so move.
Thank you, Commissioner Slater. We have a motion.
I second.
All in favor, say aye.
Aye.
Aye. All opposed, say nay. The ayes have it.
All right, thank you. Wabash 4 is now incorporated. Next, we'll go to the statements under section 20B6. I'd ask that Deputy Director Plopper pass out for the commission. I've already passed one out to the record, but for the commission, we're just going to hand you and legal counsel what has been filed as Copenhaver's statement 6. And then as well as candidate or Senator Deary's statement 6 as well. And then also a witness and exhibit list. So there are 3 documents that you're going to be handed. We've put those on the record. And I'll show you here that the candidate Copenhaver has withdrawn certain disputes in Tippecanoe County, Montgomery County. She's also withdrawn several disputes in Warren County. She's also withdrawn several disputes in Fountain County, and all of which are listed in that Exhibit 6. And then she's also removed or withdrawn various disputes in Fountain County as well. So again, this is kind of a procedural motion, commissioners. And if prepared, if I could have a motion to accept candidate Copenhaver's statement filed under Chapter 2, Section 20B6, and that each ballot identified in that statement be counted for the specified candidate or not counted in accordance with that statement.
I make such a motion.
Second.
All in favor, say aye. Aye. All opposed, say nay. The ayes have it.
Thank you. SBOA will now reflect the tally to show that those disputes have been withdrawn, and therefore the original votes will stand. Senator Deary has also filed a statement withdrawing at least one dispute in Tippecanoe County and various disputes in Fountain County. As you can see here and as on the sheet, which has been attached to the record here as well. With that, I would ask that the commission make a motion to accept candidate's statement filed under Chapter 2, Section 20B6, and that each ballot identified in that statement be counted for the specified candidate or not counted in accordance with that statement.
I so move.
Do we have a second?
I second.
All agree, say aye.
Aye.
All opposed, say nay. The ayes have it.
Thank you. SBOA is directed that they will reflect the tally to withdraw those disputes filed on behalf of Senator Deary. After that, now we have the opening statement. So with this, commissioners, I will now turn it over to the parties. Now that we've covered anything, I should ask this. Do the commissioners have any questions for me this time?
Not at this time.
All right. I have discussed with the parties kind of the way the process today. I think it's generally understood. But if there's any questions about the procedure or anything like that, feel free to stop me. At this time, we will go to opening statements and then proceed directly into the ballot challenge after that. Thank you.
I need some technical assistance.
Evan, give me some help.
Oh, there you go. Oh, that's it. Okay. I apologize.
Chairman, may I proceed?
You may.
Bill Bach, on behalf of the petitioner Paula Copenhaver from the law firm of Kroger, Gardis and Regas. Good morning. Mr. Clater asked me for a joke this morning. I told him he was going to have to give me one so I could deliver it. So maybe later in the proceedings. On May 5th, 2026, 6 counties in Indiana's Senate District 23 conducted one of the closest state house races in Indiana history. When the dust had settled on primary election evening, the tabulations from the counties reported that Republican candidate Paula Copenhaver trailed the incumbent Republican state senator Spencer Deary by 2 votes. The following morning in Tippecanoe, in disputed circumstances, which will be explained in this hearing, another vote was added to candidate Deary's total. On May 18th, Paula Copenhaver filed her petition for recount and contest, and we're here before you today in a consolidated hearing on both the request for recount and contest. In this opening, I will preview some of the legal questions likely to be addressed by the commission in this hearing. We start with the bedrock principle of Indiana election law that we discussed about 12 days ago. In Article 2, Section 1, the Indiana Constitution says all elections shall be free and equal. And the equal and free election, or the free and equal elections clause, has guided the development of Indiana election law for 175 years, nearly 2 centuries. And of course, Supreme Court decisions interpreting it are binding on both because it's constitutional provision, this commission and the state legislature. So that statutes in the Indiana Code must be interpreted consistent with that clause. So the absentee ballot requirements, which must be enforced pursuant to this clause in the Constitution, include signature verification requirements and the reliability indicators for absentee ballots that are found in Indiana Code 3-11-4-19. The reasons for this come from the nature of absentee balloting, which, as the court in Horseman, the Supreme Court said, is less reliable and more subject to potential manipulation than other forms of voting, particularly in person on election day, which is where a closed voting system is operated. So someone other than an absentee voter can open the mail and access a mail ballot. This opens the possibility that an absentee ballot can be mailed in by someone other than the voter, which makes the signature verification requirement critical. And there are statutory provisions regarding signature verification on the absentee ballot envelope to help ensure this doesn't happen. Provisions such as IC 3-11.5-4-13.5, which we will ask you to enforce today, and believe that it is not just a statutory requirement, but a constitutional requirement and under the free and equal elections clause. And under that provision, if an absentee ballot is returned and the signature on the absentee ballot envelope does not match the voter's signature on file, there are strict requirements for notifying the voter, receiving a signature verification affidavit from the voter, and then comparing the signature on the signature verification affidavit to the signature on the absentee ballot envelope itself. Only if the signature on the affidavit and the signature on the ballot match, as judged only by the county election board, can the ballot be opened and counted. So another important provision is 3-11-4-19 on the screen. This is a mandatory provision. It says a ballot that is mailed must bear the circuit court clerk's official seal and signature or facsimile signature on the back of the ballot. And it goes on to say that there must be two sets of initials on the ballot from either the absentee voter board or the appointed members of the county election board. These are mandatory requirements. They are meant to protect against disenfranchisement, which would violate the free and equal election clause of the Constitution. A second way that absentee ballots are more open to manipulation than election day ballots is that voting by an absentee voter doesn't take place in a closed environment. Although voters on election day vote in a sterile room with no candidate literature or signs and no opportunity for individuals to apply pressure to the voter, absentee voting lacks these protections. An absentee voter can be pressured by individuals who observe them voting. And absentee voters may also entrust their executed ballot to others to deliver to county officials, which creates the potential that their voted ballot could be removed and replaced with another ballot by the person entrusted with delivering the ballot. Furthermore, even if the absentee voter has not entrusted their ballot to somebody else, the possibility of ballot substitution still exists for absentee ballots. And that is why we have a statute like this that is mandatory, which we will ask the Recount Commission to enforce in this proceeding. As the Indiana Supreme Court explained in this case, Horstman versus Keller, because the absentee voter is not present at the election day polling site, the absentee voter is not exposed to the extensive precautions followed by election day officials to guard the integrity of the ballots. Even with those additional protections, the Supreme Court has explained that, quote, the provisions cannot safeguard the ballots and intent of the individual voters to the extent that provisions surrounding election day procedures can. For example, election day polling sites operate as closed environments. Therefore, quote, only precinct election officers, including the election staff, inspector, 2 judges, poll clerks, and assistant poll clerks, deputy election commissioners, authorized watchers, and precinct poll holders are permitted in the election day polling place. But a lot more people than that have access to ballots in the absentee process. In contrast, the absentee ballot is outside the control of election officials for a long period of time. And those election officials also do not have direct interaction with the voters. That is why absentee ballots have special authentication and reliability indicators, which are those indicators there, reliability indicators in 311-419. 311-419, it's important to know, is just the latest statutory iteration of a many decades old statutory requirement in the Indiana Election Code that all absentee ballots must bear these 3 indicia of reliability and authenticity: a clerk's signature, the clerk's seal, and the initials of the 2 absentee poll workers. According to the Indiana Supreme Court in Brown versus Recount, Gresco-Kawaya, these 3 indicators of reliability, quote, provide a proper identification of voters' ballots, whereby not only the voter who received the ballot, but the various election board officials would be able to determine upon examination of the ballot whether or not it was a valid official ballot which had been sent out from the county clerk's office in the manner provided by law. Thus, all absentee ballots must have these 3 reliability indicators. The presence of the seal makes it more difficult to manipulate the absentee ballot, such as by having a look-alike ballot printed. And second, the county clerk's signature on the ballot serves much of the same purposes in protecting the integrity of the ballot. And in its wisdom, the legislature has said that the seal, the signature, and the initials of the poll workers are all, as this statute says, mandatory. Now, if absentee ballots that lack the required indicators of reliability reflect a vote for candidate Deary, it is possible that his legal counsel might argue that the ballot containing a vote for candidate Deary should not be discarded on the ground that, quote, every vote should count, end quote, or that not counting the vote would disenfranchise a voter. Such an appeal to sympathy ignores two crucial aspects of Indiana's voting system. First, the reason that Indiana requires high standards to protect the integrity of absentee ballots is because absentee ballots are more susceptible to fraud and potential manipulation. Second, were the Recount Commission to relax the statutorily required reliability indicators for absentee ballots, it would risk diluting votes and disenfranchising voters. These risks are high in any election, but here in this election, the risk is even higher, where the candidates are only separated by a handful of votes, meaning that just a few invalid votes, perhaps only one or two, could swing the election. Therefore, maintaining the statutorily mandated reliability indicators for absentee ballots does not disenfranchise voters. It protects against valid votes being diluted by invalid votes. Those reliability indicators are necessary to ensure that valid absentee voters and valid election day voters are not disenfranchised through counting invalid, potentially manipulated absentee ballots. Now, is it possible that a missing seal or signature or initials was the result of a mistake by an election official? Yes, it's possible. But it still does not change the mandatory nature of these absentee ballot reliability indicators, which exist to establish the authenticity of absentee ballots, which by definition are handled outside the closed environment of election day. It's also important to consider the duty of voters. One of the statutes we're going to talk about in a little bit provides some opportunities in certain instances, we argue, not with respect to absentee ballots, to overlook mistakes by election officials. But that statute says that those mistakes must be the sole cause of the ballot not being counted. So it's important to understand that Indiana law provides, and numerous cases indicate, that the failure of a voter to see and look for the reliability indicators, the seal, the signature, and the initials, is fault by the voter. Such that in Werber versus Hughes in Indiana Supreme Court, the court said that if an absentee ballot lacks any of the statutory requirements of identification when it comes into the absentee voters, it is then lacking in some one or more of these things which are required to make an official ballot. So that statutory provision that I would like to quickly talk about did I just see you correctly that I have a minute left?
Yes.
Okay. We'll be talking about this statute, I'm sure, throughout the course of the day, but I just want to make 5 quick points because there are 5 things that this commission must find before a ballot can be so-called cured and voted if any problems exist, mandatory problems exist with the ballot. First, the provision says the ballot must have been marked and cast by a voter in compliance with this title. That may not have happened, and we argue that it has not happened. It's not been cast in compliance with the title if it doesn't have those reliability indicators on it when the voter sends it back. So these casting of the ballot, things that are on the ballot, we argue are not covered, and absentee ballots are not covered by the statute. Second, the reason the ballot may not be counted must be solely as the result of the failure of an election official. As I just, yeah, okay. Could I finish my list of five?
If okay with the commissioners?
Yeah,
Thank you.
I'd make a motion that both sides get an additional 3 minutes.
Second.
Do you agree with that?
Yes.
Okay, so go ahead, please.
Sure, and thank you very much. I appreciate it. So secondly, this provision says that a ballot that may not be counted must be solely as the result of the act or failure of an election officer. With an absentee ballot, when the reliability indicators of seal signature or initials are not present, that is visible to the absentee voter. And the failure is not solely the result of the act or failure of the election official. Another reason this statute doesn't apply to absentee ballots. Third, there is an exception in section 13, specifically related to the initials. Fourth, the counting of the ballot is not mandatory. It says may nevertheless be counted. And I'll have some comments related to that provision because there is no standard in the statute or elsewhere by which this commission can judge whether to count it or not. And it creates standardless discretion. So I don't have time to go into how that should be interpreted, but it's a fourth reason why I believe this statute cannot apply to absentee ballots. And the fifth and final is that if there's evidence of fraud, tampering, or misconduct, and we will present evidence of misconduct affecting the integrity of the ballot in Tippecanoe County, and that may affect 2 votes, or 2 to 4, maybe 6 votes, depending on how the commission views it. That also means that ballot cannot be counted. So those are the 5 reasons. Thank you very much.
Thank you, Mr. Bulk. Ms. DeWester?
Thank you.
In 18 minutes.
I'm not going to use 18 minutes. I'll use 1. Thank you. I'm Samantha DeWester. I'm here on behalf of Senator Spencer Deary. I obviously disagree with a lot of what he just said, and we'll reserve my comments for argument on the contest individually with the ballots. Thank you.
Thank you, Ms. DeWester. Mr. Norris?
Yes, thank you, Mr. Secretary. At this time, we will move into the ballot by ballot, precinct by precinct disputes. I note for the record that we have 3 precincts in Montgomery County. They would be Brown, Ripley, and Wayne. And we are supposed to go starting with petitioner in alphanumeric order, which I will show as Ripley precinct being the first dispute within the petitioner's case in chief. Yes, and counsel, if you would like SBOA to grab the physical ballots, if you could just let us know that ahead of time.
Okay.
So we can go move forward that way.
Yeah, and so I had a different understanding, and my slides are off because of that. My understanding of alphanumeric was the alpha was the county, and then but it's apparently precinct, and then number, because I thought that we would go by Yeah, so,
exhibit number within the count.
yeah, well, the way I was gonna do it was alphabetical through the count. So sometimes there's like a Troy 1, Troy 2, Troy 3, Troy 4,
Mhm.
and I was gonna run through it that way.
Oh, I see.
If we want, I will just, if you ask me for your first exhibit in particular, I believe that is Ripley County
Yeah,
or Ripley precinct.
we have Wayne Exhibit 3 would be the one that is first in the order here, but I can just skip through and find it.
That's fine. We'll start with Wayne.
It's at 3, okay. I did want to make it clear to the commissioners that we have provided exhibit binders, and I'll be referring to tabs within the binders so that you can find it easily. In some cases, I'll have, pictures on the screen, but not necessarily in all cases. And so if there's any question on where we are, please let me know. What we would request is that the commission first consider the declaration of Karen Douglas, which we have provided under tab 8 of the binder. Karen Douglas is a former clerk in Montgomery County, having served 9 years as the voter registration deputy from 2007 to 2016. And then was clerk from 2017 through December 31st, 2023. And I would direct the commission's attention to her statements, really beginning, I think, with paragraph 6, or really sentence 6, because they're all just one sentence paragraphs, where she says she's familiar with Indiana's election laws. She's familiar with 3-11-10-26.1, which states that voting before an absentee voter board under section 26 of this chapter shall be referred to as early voting on all forms prescribed by the election division and in communication with all voters. She also notes the applicability of 3-11-10-26, which provides that as an alternative to voting by mail, the voter is entitled to cast an absentee ballot before an absentee voter board. And the point, I think, of her referencing those statutes in her declaration is that the absentee or the early voting process in Montgomery County, and we're about to show you some early voting ballots, are absentee ballots and considered by code absentee ballots. She affirms that the early voting process used in Montgomery County is absentee voting before an absentee voter board. We provided her with copies of exhibits 3, 6, and 7, which I'll show you in a second. And she affirms that those are true, are inaccurate copies, and that she's reviewed those exhibits in paragraph 11. And she said that each of those 3 exhibits are early voting ballots used in Montgomery County. And she affirms in paragraph 13 that she understands that all early voting ballots must comply with the Indiana statutes governing absentee voting. And she affirms in paragraph 14 that she understands that an absentee ballot voted before an absentee voter board must bear the county court clerk's official seal and signature or facsimile signature on the back of the ballot. Paragraph 15, she affirms that she understands that pursuant to Indiana Code 3549, the only time in which a county clerk is permitted not to include her signature on the back of the ballot is when they are on the ballot for an office other than the political position, and the clerk's seal serves to authenticate the absentee ballot, verify its official issuance.
Can I interject? Are we just going to read the entire affidavit into the record? Because I have an objection to this affidavit being submitted as to relevancy.
I'm going to let him read it, and you can object to it on your response.
Okay, then it'll have to be stricken from the record, I guess.
It will take it up to consideration at that time.
And she affirms that she knows that in 2026, the Montgomery County Circuit Court Clerk was not up for election other than as a convention delegate, a political position, which would not eliminate the signature requirement on absentee ballots. Paragraph 18, she notes the requirements in 2 places in the Indiana Code for absentee ballots voted before the absentee voter board, including in early voting to have 2 sets of initials from the absentee voter board. She notes that Montgomery Exhibit 3 is an early voting ballot, an absentee ballot required to contain 2 sets of initials. And Exhibit 6 and 7, she says in paragraphs 20, 21, were early absentee voting, absentee ballots required to have the clerk's signature and did not have them. And then finally in paragraph 22, she says, in my experience with recounts as the Montgomery County Circuit Court Clerk, early voting ballots which lack the county clerk's seal or the county clerk's signature, which lack the initials of one or both members of the absentee voter board, are not counted in the recount. And then after that is her signatures.
Do I have an opportunity to respond to that?
Yeah, so we are going ballot by ballot. So do you have any specific arguments with regard to Exhibit 3 that we're trying to get to?
Well, I'm just responding to the affidavit because it's completely irrelevant. It should not be admitted into evidence because someone that used to be a clerk signed an affidavit regarding evidence in a recount to which she was not a party or even remotely involved. I don't care what she thinks or says or opines about Title III. That's what these folks are here for, not somebody that's not related to this action.
And if I could respond just briefly. It's important for us to identify because it's not inherent in many ballots. And so for every ballot that we say is an absentee ballot, we have a witness that says that is in fact an absentee ballot, somebody that's familiar with the system in the county, so that we're not guessing based on how we think about ballots look like, or we're not supposing whether it's an absentee ballot or not. So her testimony in her affidavit or declaration is important because she does have the expertise with Montgomery County elections to be able to identify whether or not this is an early voting and absentee ballot.
And I believe the commission can look at the law. That's why they have lawyers on each side of them. If they need any help interpreting the law, they don't need a random retired clerk from a county telling them what is legitimate and what is not. It's not relevant to this whatsoever. Her testimony wouldn't be allowed in any normal situation in a court or whatnot. So I would object to it being admitted for the record.
So commissioners, this is the point in time where I probably need to defer to the commission on an issue like this because it does go to the ultimate question of the ballot. And in this particular instance, I will just note for the commission that the Indiana rules of evidence don't necessarily apply, that the Indiana trial rules don't necessarily apply. And so therefore, the commission's responsibility is to see the process through the forum. So whether or not, in my opinion, if the commission wants the affidavit to come in, it's just another piece of evidence for you to consider, or not. And leave it up to you and perhaps legal counsel to provide any input that they would like.
Thank you, Mr. Norris. Yes, Mr. Clay.
Just to make a comment, and please tell me if I'm reading this wrong. The 312.113 says this section applies only to absentee ballots, early voting ballots, or absentee ballots. It says the whole ballot may not be counted unless the ballot is endorsed and goes on for code sites. So if you show me a piece of paper that shows this is an early voting ballot and it has 1 set of initial, the Recount Commission cannot count it as a valid ballot under 312.113. And I don't know why we need any of this paper other than that piece of paper that shows an early voting ballot with 1 set of initials. I don't want to be here till December 31st going through this information when I believe, and maybe I'm wrong and the other commissioners feel otherwise, but I don't know that we need anything other than, here's the ballot, here's the deficiency, rule on it. If we can't figure out how to rule on it, maybe they can argue at that point. But if the evidence is before us and it shows an absentee ballot with one set of initials, I think we're done.
Thank you, Commissioner Clayton. Commissioner Muller.
I mean, I was prepared to hear out both sides' arguments and rebuttal and listen. Although I hear what you're saying and it's rational.
Will we make a motion to accept, to reject? What?
I think what's before the commission right now is whether or not to accept this affidavit that candidate Copenhaver has put before the commission, whether to accept it or whether to reject it as Senator Deary's counsel is requesting into the record.
Yeah, I would move to accept it into the record with the caveat that we've heard the contrary opinion from the opposing side, and it's just evidence to be considered and nothing more than that.
I second that.
All right, vote.
Those in favor say aye.
Aye.
Aye. Those opposed say nay.
Nay.
2-1. The ayes have it.
We'll show that the affidavit that's being discussed from the former clerk will be admitted into the record for these proceedings.
Then moving on to Montgomery Exhibit 13 and Wayne Precinct.
Exhibit 3.
Did I say 13? Exhibit 3, sorry. Thank you. This, as we've said, is an early voting ballot, therefore an absentee ballot. It lacks one of the required sets of initials, and for that reason, Petitioner Copenhaver suggests that the commission should find the ballot invalid and not count votes on the ballot.
Response.
I agree. I mean, I'm not going to waste your time arguing why this should count when my experience with lots of recounts, it's not going to count. And you just, Commissioner Clayton just said, if it doesn't have to, we're not going to count it.
Right.
So outside of voter intent and, the statutes that say, they shouldn't be disenfranchised because of clerk error. This is an absentee ballot. It's early voting. I think we all know that and agree to that.
I motion to reject the ballot.
Second.
All those in favor say aye. Aye. All those opposed say nay. The ayes have it.
Thank you. So we will show that Exhibit 3, which was a valid vote for candidate Deary, has now been rejected and withdrawn as a valid vote for candidate Deary in this particular precinct. I have is candidate Copenhaver has Exhibit 6, I believe.
Yes. Okay, Exhibit 6. Yeah, good. Is on the screen, and if we look at the next, lost my picture here. Okay, this is a comparison of Exhibit 3 that we just saw that shows the defect in Exhibit 6, which is that there is no clerk signature. As we shared, pursuant early in our opening, pursuant to 311-419B and Indiana Code 3-11-10-27, the clerk's signature is a mandatory aspect and reliability indicator on absentee ballots. And for that reason, we submit that the commission should find this ballot invalid and not be counted. This is something that the voter could have identified, and as a result, the saving statute could not apply for all the reasons I've said before, including the fact that any failure caused by this is both the fault of the voter as well as election officials if this is a valid ballot. But it's not a valid ballot because it doesn't have the three reliability indicators, and all three of them are in the statute, and all three of them are required. So it cannot be just supposed that this is a valid ballot and that there was a mistake made by an election official. There's no evidence that there's a mistake made by an election official. We see the ballot on the left where the clerk did sign it. So obviously the clerk was signing absentee ballots in the county. And so the failure to have that reliability indicator, which is mandatory by statute, should invalidate this ballot.
Mr. Wester.
Thank you. So since it was an early vote in person, I know it's kind of a hybrid of the law. Obviously, it's absentee ballot, but voting in person obviously removes any concern about mail out of the reach of, the people at the vote center, et cetera. Nowhere in code, what they fail to mention is that it is mandated that a ballot will be tossed, an absentee ballot will be tossed because it's missing the clerk's signature. I don't know why. There are some that have the signature. That's a clerk issue, right? That's the election board approved the ballots. All the vendors are approved through the Secretary of State's office under 311.5-4-13, where it mandates the rejection of absentee ballots and it outlines the specific reasons why absentee ballots shall be rejected. The General Assembly did not say because the clerk forgot to put her signature or facsimile of her signature on a ballot. That's not included anywhere. On the ballots that they are challenging, both initials by either party are there. The clerk stamp is there. The person was an early voter in person. Nowhere in code does it say that if those trifecta of things are missing, the ballot is immediately invalid. What it does say, if it's missing both, then it shall not be counted. Outside of that, there's no provision for this commission to rely on that says, due to a clerk error or issue or oversight, outside the absence of any fraud or misconduct or tampering, you shouldn't consider an error of where are the things going? You shouldn't consider an error of the clerks or election officials to be on the voter. I completely disagree that the voter has some kind of duty to review the ballot to make sure and know every aspect of Title III. I don't think anybody in this room knows every caveat of Title III. I certainly don't. So I can't imagine a voter having to know, like, well, it's missing a set of initials. I got to send this back. My fault. I filled it out. I should have known better. That's an absurdity. We don't put the burden on the voters. The burden's on them to show why a vote shouldn't count. This is a valid ballot. Nothing that they've said makes it invalid. Nothing in code says it's invalid. Nothing in code says that it cannot be counted, and it should be counted. It's already counted. And to disenfranchise a voter because of missing facsimile of a signature, which my guess the General Assembly enacted so that someone knows it's an actual, ballot, not, a random spam ballot that someone might send to you, but the clerk stamp is on there as well. It should in no way take away their vote just because a missing signature. Everything else is legitimate about it.
Thank you, Mr. Wester. Mr. Norris.
Can I have rebuttal too?
Yeah, I think during these, Mr. Secretary, I think we should at least allow the parties a fair opportunity. If you're fine with it.
I agree as long as both commissioners
Yes.
agree.
I agree.
Go ahead.
Okay, very good. Thank you. So, I appreciate, obviously, both of us are advocates and we're here to make arguments, but arguments are not evidence. Mr. Wester said repeatedly, this is a valid ballot. We're only entitled to consider it a valid ballot if it meets the requirements of the absentee ballot statutes, which I've already read, which indicate that it has to have a seal, it has to have the signature, and it has to have, and these are mandatory requirements, it must have the initials. Each of those things is what make it a valid ballot. So this is by law not a valid ballot. Now, she has said that this is a mistake by the election board. She hasn't suggested how that mistake came about. And that's her burden, because she's suggesting that the court should, or I'm sorry, the commission should apply a statute such as 312.112 to count the ballot. And so that statute only applies if it's a valid ballot, it's been marked and cast by the voter in compliance with this title, and you can't cast an invalid ballot that and say that you've done it in compliance with this title. And it can't be solely the result of the failure to act of an election officer. Maybe if this were a mistake by an election officer, which we don't know, maybe they're more at fault than a voter, but you can't say it's solely the result of the act or failure to act of the election officer, because the code allows an absentee voter to bring the ballot back. And additionally, I want to point out now the statutory ambiguity in 312.112. The statute says that if this election, this recount commission can either count the ballot or because it uses the term may nevertheless be counted. So you have it within your discretion, according to the statute, to count or not count a ballot based on the statute. That is the epitome of unconstitutional standardless discretion. Because the Indiana or General Assembly has given you no basis on which to exercise your discretion. So if I believe what will happen is if you were to count this ballot, you would be exercising discretion without a standard provided by the General Assembly. And I think that the best way to interpret this statute is that when it comes to absentee ballots, which we've already established are subject to higher standards and higher requirements, that this statute should be interpreted as not allowing the counting of a absentee ballot that is missing reliability criteria. So for those reasons, we believe that the commission should protect the validly voted ballots against the potential for dilution that this ballot presents.
Just briefly, and the Supreme Court, pardon me, explains, these kinds of issues within Horseman case, and it explains why the General Assembly specifically outlined the completely separate statute for absentee ballots, but also the rejection of them. If the General Assembly wanted this commission or every election board or absentee ballot counters at central count after every election to reject every single ballot that's missing a clerk stamp signature, they would have put that in there. I can only imagine how many thousands, hundreds of thousands of ballots possibly, depending on clerk error, would keep people from voting. We're here to talk about an election, and Horseman talks about how to liberally construe the statutes, not so constrict that a signature stamp from a clerk with everything else that's there is what would kick the ballot and make it invalid. And this is an early ballot that was voted in person. So someone is there showing their ID, what they are. Why on earth would we say your vote doesn't count because there's not a stamp on the backside of the ballot? That doesn't make any sense. So again, I would ask that this ballot be counted as it has.
Thank you, Mr. Wester. I think at this point, I'd like to ask the commissioners if they have any questions.
Just a comment, if you don't mind.
You may.
Reading the sections 12 and 13 together. and looking at, would you mind putting 12 back up there
Yeah, yeah,
that you had? Sorry to make you do my work for me.
that's okay.
But reading 12 and 13 together, these are the sections that talk about whether or not we count things. And in B, where it says except as provided in 13, and 13 is the one that makes it very clear that if we're missing a an absentee ballot officer, but the absentee voter board said initials, it's done, it's gone. Seal or signature, we have the discretion, which the legislature gives a lot of officials discretion that they can add under C to count it or not. That's totally up to whether we think, if you actually think there's 10,000 pieces of paper and the clerk signing every one of them to do ballots, fine, you can think that. But those things are printed on, stamped on, and somebody screwed up. So in those situations where somebody screwed up, and it's not an absentee ballot voter board that screwed up because those are done, then we have the discretion to decide whether we believe that was an error by an election official. And that's just discretionary. So we can vote to count it, we can vote not to count it. I personally will vote to count it because I believe that's an error by an election official. And we are to err when we can. When the legislature says we can't do this, we can't do it. But when the legislature says we can figure it out and count it or not, I lean towards counting.
Thank you, Commissioner Claytor. Commissioner Merlin, do you have any comments or
No
questions?
comments, no questions. Thank you.
Mr. Norris, anything to add?
No, Mr. Secretary, I will just again note that this is Exhibit 6 within the Ripley precinct within Montgomery County, and it was a vote that was counted towards candidate Deary. So at this point, the commission has whether to accept the ballot, which was a vote for candidate Deary, or reject the ballot completely based upon council's arguments.
Mr. Chairman, I move we accept the ballot as a valid ballot.
Do we have a second? Yes, we don't have a second.
If there's a second.
Then my motion dies.
Any questions before we make a final decision here?
I think this time that there was no second for that motion. So if there's another motion that may get a second, they present that motion at this time.
Do we have another second? No?
Wait, this is the motion for what?
To reject it.
Oh,
Do you mind to explain, elaborate a little more, Mr. Norris?
Yeah, so Commissioner Claytor made a motion to accept the ballot, which was counted towards candidate Deary. That motion did not get a second. The next motion would be perceivably, or some other motion would be to reject this ballot, which was a vote for candidate Deary, and throw out this ballot based upon council's arguments. So if there was no second for the first motion, it's either accept the ballot or reject the ballot.
Thank you, Ms. Norris. Do we have a second?
You need a
Second.
motion.
Gotta make a
Was it-
motion first.
Do we have a motion to accept? Do we have a motion?
I make a motion to reject the ballot based on council's argument.
I second it. Those in favor say aye.
Aye.
Those opposed say nay.
Nay.
2-1, the ayes have it.
Okay. For our purposes, then we will show that a vote 2-1 that Exhibit 6 in Montgomery County Ripley precinct, which was a vote for candidate Deary, has been rejected and thrown out. Next, I have on my list, I believe it's Exhibit 7,
Yes.
which is another Ripley County or Ripley precinct, like Montgomery County?
This is, and our position is the same with respect to Exhibit 7. It also lacks, it's the last exhibit we'll present in Montgomery County, and it also lacks the clerk's signature. And I won't repeat my arguments for the same reasons that we requested the Exhibit 6 not be counted. We request the Exhibit 7, which is in all respects identical, not be counted.
Do you have any?
I'd like to make an argument. Thank you for the record. I again will reassert the same arguments I did on the previous ballot. Nothing in code, case law, anything gives this commission the ability to deny because a clerk didn't put a signature on after the 12-step process of absentee ballots of requesting one, mailing one, signatures, putting your social security number last four or driver's license number to have, because there's a clerk stamp missing, it invalidates the vote. Is that where we are now? Really? I mean, this should count. This is a legitimate vote. State Board of Accounts counted it as valid, but now we're going to say because the clerk didn't put a stamp on there that this person doesn't get to vote. And I'm going to ask, I guess, because the statute says the whole ballot's tossed. So does that affect all the other votes on said ballot? I know they're not part of the recount, but it says the whole ballot will not count. So will we, I mean, if we're going to take off the counts from, if we're going to disenfranchise voters, if that's where we are in Indiana law, because of a clerk signature, might want to get counsel from council to see if we then remove all the other totals from the rest of the people on the ballot. That's what the statute says. The whole ballot is tossed.
My rebuttal will be very short. Obviously, consistency is important, and I won't repeat arguments I've made about why the reliability indicators are important. I will say that the State Board of Accounts, which was referenced by Ms. DeWester, they aren't making judgment calls on what is a reliable ballot, and they aren't making those calls that this commission is empowered to make. So the fact that they what they did is entirely irrelevant before the commission. And again, just on the disenfranchisement point, protecting the integrity of the ballot and votes protects votes that have been validly voted, and it's not disenfranchisement to enforce the election code.
Well,
That's
but it is when you're taking away someone's vote that they had nothing to do with this. They went to the polling site with their ID. Everything's legitimate except for a stamp. The Secretary of State's office is responsible for training all of the clerks. So if there's a training issue, I guess you could address that with them. But to tell someone their vote no longer counts, or possibly their entire ballot, which is what the statute says, then there's going to be a whole slew of ongoing problems in the future, because there is nothing in case law that says a missing stamp somehow invalidates this and makes it possible fraud or some issue. There's nothing in code that says you need to throw this out. If the General Assembly wanted to have you reject this, they would have added it to the site that I previously cited, rejection of absentee ballots. Ballots shall be rejected if, that's under 311-5-4-13. This was not added to that section. It's only the opposing party clerk initials, not a random clerk signature that wasn't put on a ballot. And again, this person would have appeared in person with ID as a whole. And I get that it's still considered absentee, but this person's vote and the prior one should not be tossed because a clerk made a mistake and didn't put a signature on something.
Thank you both. Mr. Norris?
Yes, thank you. Any other comments at this time? I would direct the commission that this is Exhibit 7, which again is Ripley Precinct, which is was counted as a vote for Senator Deary in the election. And the commission now, I believe, has two options, whether to accept that ballot that was casted for candidate Deary, or excuse me, Senator Deary, or they can reject that ballot.
Thank you, Mr. Norris.
Mr. Chairman, I make a motion to reject the ballot consistent with the reasons of the previous one.
Do we have a second? I second it. All in favor say aye. Aye. All opposed say nay.
Nay.
2-1, the ayes have it.
So just to clarify, is that taking the whole ballot out? So all of the other people that were voted on,
They're
it
not
will then be
part of the
removed?
recount. You're just making.
Well, no, I'm just asking because that's what the statute says. The whole ballot gets tossed.
They're not part of the recount.
Okay.
So thank you, commissioners. We will now show that Exhibit 7 within Ripley precinct within Montgomery County has now been rejected as a ballot that was cast for candidate Erie. Next, I have Exhibit 4 in Wayne for candidate Erie. And I will remind the commission as well, we do have we have the state police present in the back there hanging out. They have brought the physical ballots. So if at any point in time, the commission would like to see a physical ballot, please just ask and Deputy Examiner Goucher will grab that for you. Thank you.
Thank you, Ms. Norris.
I guess before we get started, do they have the ballot sleeves in there? What would have been mailed out? Well, I guess these were early votes in person. The ballot sleeves for future. Yes, it's strike that. Okay, ballot 4 or Exhibit 4 is in Montgomery County under the code. Previously discussed, it's an absentee ballot missing both initials and ironically the signature. So under Indiana code that I previously cited, it should not count. And that's a ballot for Copenhagen pursuant to 11.5-4-13 and under 312-113. Both initials are missing from the absentee ballot, which is an early ballot.
We agree with Ms. Wester. We don't have an argument that the ballot should be counted. We don't believe it should.
Thank you both. I think it's
I'm lost. Could we go over what precinct are we again?
Yes, I will go over one more time. We are in Wayne precinct in Montgomery County. This was a dispute brought by candidate Erie. And I have a copy of Exhibit 4 prepared if the commission would like to review Exhibit 4 so that they can see it in person.
Would you like to review it, commissioners?
It wouldn't mind just seeing it. It's missing both absentee board initials, correct?
I believe that's the argument.
Okay.
That's correct.
And I believe that's conceded at this point. So
Okay. Then I move that we not count that exhibit.
I second that.
Uh,
Second that.
Thank you. All in favor, say aye.
I
All opposed, say nay. The ayes have it.
thank you. We will show then for the record that Exhibit 4 in Montgomery County, which was a vote counted towards candidate Copenhagen in Wayne precinct, has been rejected.
Director Norris. Not sure if the commissioners, if everybody would like to take a 10 minutes break before we continue to get moving, or we can stay. It's up to all of you.
We have one, I believe we have one more ballot in this,
Oh, for this,
for this county.
perfect.
And then maybe we can take a break after that.
That's perfect.
I will show next that we have Exhibit 5 in Brown precinct, which was disputed by candidate Deary.
This is also the same argument as my previous argument. There are no clerk initials on this ballot, making it invalid. It's an absentee ballot that was cast as well.
Thank you, Mr. Wester. Mr. Bob?
Yes. I'm gonna go pull the ballot up. Okay. So as the commission can see, this ballot is dramatically different than the previous 4 ballots. The commission has considered, unlike the early voting absentee ballots considered to this point, there's nothing on the ballot that indicates that this is an absentee ballot. In fact, the ballot says official ballot Republican primary election, Montgomery County, Indiana, May 5th, 2026. The commission will recall that the petitioner presented evidence in the form of the declaration of Karen Douglas that specifically identified the early voting absentees to be absentee ballots, subject to the reliability indicators that apply to all absentee ballots. In contrast, the respondent has presented no evidence that this is an absentee ballot. I'd like to turn the commission's attention to the declaration of Michelle Petrick, the former Warren County clerk and a Warren County election board member, who notes in her declaration, which is under tab 11, at paragraph 11, that pursuant to Indiana Code 3-11-14-19, a county must provide paper ballots to a voting location where the voting system is out of order or does not work. There's nothing on the face of this ballot that would indicate that it is an absentee ballot, rather than, for example, a paper ballot used due to a voting system not working. In that regard, I note what's highlighted there in the upper left-hand corner of the ballot, at which is the statement, quote, "If you make a mistake, return your ballot to the election official and obtain another. Do not attempt to erase any marks made in error." This instruction might be seen on a ballot used at a polling location where election officials are present. So for all these reasons, respondent has not met his burden of establishing that this ballot, Montgomery Exhibit 5, is an absentee ballot. Therefore, the ballot shouldn't presumptively be treated as an absentee ballot. And as a result, the respondent has not carried, Mr. Deary, the respondent, has not carried his burden of establishing an absentee ballot. Then IC 312-1-12 wouldn't, I'm sorry, 312-1-13, which applies only to absentee ballots, doesn't apply. And any other statute applying to absentee ballots, which are the only ones that have been discussed so far, doesn't apply. And for those reasons, petitioner submits that this ballot, because of lack of proof that it's an absentee ballot, should be accepted.
And again, I don't care what the Warren County former clerk or whomever has to say about a Montgomery County ballot. Clearly, electronic voting, early voting was done electronically in person. The system that's used is Unisys. We counted all the ballots. I'm happy to crack open one of the boxes here and see the absentee ballots, because this is an absentee ballot. Everything else is electronic in the county. We were not made aware of, SBOA was not made aware of any type of shutdown issue problem. Mr. Norris was not made aware of any type of shutdown that would allow for ballots just to be handed out willy-nilly that were not absentee ballots. This is clearly a mail-in absentee ballot. I assume maybe the digital tracing around it says that it's an absentee ballot. I don't know if we want to rescan it or what we want to do, but it's clearly an absentee ballot. All their voting is done electronically. We know that because we were boots on the ground and went through every single ballot in 6 counties.
Thank you, Mr. Wester. Any questions or comments from the commissioners?
Do we have that exhibit?
Yes, we do. Question for Mr. Wester. Does it say Brown out of town at the top of the second page?
Yes.
Like, what do you know what that means?
Now,
Or is that standard?
it's something, yeah.
I think it's enough for you.
Yes, Commissioner, there are certain precincts in certain counties where there is a municipality located there. That indicates that that's a split. Usually it's only for municipal elections, or in the case of like this election, there's a school corporation. So they need to differentiate, hey, there are certain voters that live outside of, in this case, the municipality, and those who live inside the municipalities. It'll be more important for next year when they're conducting a vote, making sure that voters who live in the municipality are the only ones who are voting. So that's why it's just indicating for legal purposes that this precinct is split along a particular election district.
Excellent. Thank you.
Approach.
Yes, please.
Pass it down there. This is exhibit 5. Commissioners, I believe Deputy Premier Gallagher has something to add very quickly.
Please, you may.
Just, state counts did count this as an absentee ballot.
Thank you. Thank you all. Any other questions or comments at this point?
Mr. Chairman, I move that we not count this ballot.
There's a motion to reject the ballot. Do we have a second?
I'll second.
All in favor, say aye.
Aye.
All opposed, say nay. The ayes have it.
Thank you, Mr. Secretary. We will show that Exhibit 5 in Montgomery County in the Brown precinct, which was a vote counted for candidate Copenhaver, has been a rejected ballot. And then at this time, Mr. Secretary, if you'd like to take a 10-minute break, return at maybe, let's say 10:50, and then I'll report the final numbers from Montgomery County because that ends, I believe, all of our disputes in that.
That sounds good.
All right, we'll be back in 10. Thank you.
believe all parties are here, so we're gonna continue. Mr. Bob?
Thank you
You
very
have the
much,
floor.
Mr. Chairman. Mr. Secretary of State, absolutely.
And I just want to report very quickly, now that we're finished with Montgomery County, I want to just provide the commission with the update on the results. The certified election results that were turned into the election division showed candidate Copenhaver with 393 votes and candidate Deary with 223 votes. Following today's adjustments of the tally, here are the new vote totals that will be sent to the Indiana Election Division. For candidate Copenhaver, 391 votes. For candidate Deary, 220 votes. And those are the Montgomery County totals. Next, I think we're going to move on to Warren. Thank you.
Mr. Chairman, members of the commission, regarding Warren County, I think I need to correct a statement I made earlier on the record. I think I referred to the declaration of Michelle Hetrick as Exhibit 11 on the record earlier. It's actually, it's under our tab 9 in the binder that we've provided. She is a current member of the Warren County Election Board. She was formerly the clerk for one term, as indicated. I won't go through her declaration there, other than to say that she does identify exhibits 56 and 57 as mailed. I just want to make sure that she says mailed, mailed absentee ballots. Yes, in paragraph 9, I can confirm that Warren County exhibits 56 and 57, which we're going to show you right now, are mailed absentee ballots. So this is exhibit 56. It's in precinct Washington 2. And could we present both of them together? You want us just to present one at a time?
Yeah, we can, the guidelines permit us to group exhibits together.
Okay. So as the commission can see, this is a mailed absentee ballot, which lacks the clerk seal and which also lacks the clerk's signature. So for both of those reasons, those two of the three reliability criteria required by statute, on exhibit 56 and 57, we are requesting, for all the reasons that have already been argued and discussed related to Montgomery County, they apply with double force to this ballot that not only lacks the signature of the clerk, but also lacks the seal of the county. We request that exhibits 56 and 57 be considered invalid ballots and not voted. Thank you.
Thank you. Mr. Wester?
Yes, I'm going to respond with the same arguments that I've had previously. Nothing in code or case law says, I know that they're trying to say that there are 3 triggers that make a ballot valid. That's just patently false, because a clerk failed to do what they had to do by law. Your office trains them. If they didn't follow the protocol, somebody needs to be retrained. That shouldn't disenfranchise voters. Votes should not be tossed because everything else is legitimately correct. There are initials. Everything was done properly. This is a several-week process, as you know, to request a ballot, send it back. The election boards, they vote on the ballot. They know what it's going to look like. Why are we holding voters to account for a mistake of the election official or election officials? It's unheard of to me. I've never seen that done. It's one thing to maybe question a ballot because 2 parties didn't initial a mail-in ballot, but to do it because there's a stamp missing, And I mean, the Secretary of State's office certifies every single one of the vendors. That works. Maybe we need to look at all the vendor lists and get new vendors. If these ballots aren't going to be properly done or printed out or done by, I guess, the new standard of what we want ballots to be. But I would strongly object to these being invalidated because of a missing clerk signature or stamp.
Thank you. Any questions or comments from the commission?
So,
We're gonna make them.
yeah, I'll make a motion to reject these two ballots.
I second. All in favor, say aye.
Aye.
Aye. All opposed, say nay.
Nay.
2-1, the ayes have it.
Thank you. I will show for the record then that exhibits 56 and 57, which were both votes for candidate Deary in the Washington 2 precinct of Warren County, have been rejected by the commission.
Thank you, Mr. Norris.
Next dispute.
The last dispute in Warren County that we'd like to present is with respect to Exhibit 33. And I do want to make something clear on the record related to this exhibit and to the declaration of Sarah Visper that is under tab 10 in our exhibit binder, that we've had, council has had a conversation with the recount director. The individual that we believe voted exhibit 33 stated on social media they are a resident of Liberty Township in Warren County, and they stated on social media that they voted a ballot solely for candidate Deary and no other candidates. We, since being denied the opportunity to take discovery, we did additional research that I think does a very good job of establishing that the voter who will only call Sam so as not to put his full name out there on the video, but keep in mind, he's gone on social media and said who he voted for and held up on social media a certificate showing that he voted in this precinct in the Republican primary on the election day. And we believe that the only reasonable conclusion is that we have found his ballot. And he acknowledged that he was a crossover voter, that he hadn't voted in a Republican primary ever before. We've provided social media posts regarding the 2023 and 2024 elections, where he said that he encouraged people to vote for non-MAGA and non-Republican candidates. And we know that somehow, he's not been spoofed or his identity has not been stolen, because he is identified with a business, the Niches Land Trust, that operates in Fountain, Warren, Tippecanoe counties, and has an office actually in Tippecanoe County. And his picture is in that on the website for that business. And it's this the same person who is on these social media accounts saying that they are encouraging people to vote for Democrat candidates. And I recall you to what we said about this individual, who's obviously a very active individual in the community and has strong opinions, and that's great. It's just that he wasn't legally entitled to vote in the Republican primary. And I'm not going to take a run at every ballot in all these different counties. But we think that we have identified the ballot by this individual who said that he decided not to vote in the Democrat primary and voted in the Republican primary for the first time for the sole purpose of defeating the MAGA candidate and voting for Mr. Deary. We believe that that is inconsistent with the eligibility requirements of the Indiana Code. We believe that we have proven that through the social media research that we've done without the need for deposing the voter. And we would ask for the exclusion of his vote. You said that he voted for Mr. Deary. We asked for the exclusion of Exhibit 33. The ballot is Exhibit 33 because that is the only one in the county that this individual, who, by the way, is the only individual with this name that is a current registered voter in the entire state of Indiana. We believe we've proved that that ballot was improperly voted in the Republican primary and would ask it be excluded. That's Exhibit 33. I don't have a picture of it.
Thank you. So, Mr. Wester.
Thank you. I mean, if this is going to be admitted into the record, it's public. So you might as well say his name so he knows that he's being called out for what he said on social media, if that's where we are. They have not proven anything that would allow this commission to pull a random vote and say, because of what he said on social media, he cannot vote in this primary election. It is 100% hearsay. I don't care if there's only one of them registered. You don't know who says what on social media, if it's true, if it has any validity to it. I don't care that we should not be here talking about what people post on social media and whether their vote counts. We can't be at this place in Indiana. Our elections are secure, and we absolutely need to keep this ballot in and not with all the social media stuff that they pulled off. That's neat. It has no bearing on someone's fundamental right to vote. And then for a commission to take it away based on negative things said on social media is unprecedented. So I strongly object to this being rejected. It should remain counted. State Board of Accounts counted it as a valid vote as well. I don't know how they dug up whatever they did and tied it to social media stuff. Apparently they have stronger powers than anybody else with elections. But there's no way we should disenfranchise someone because of what their comments are on social media. There's nothing that shows that they weren't a valid voter. And again, her chance to challenge people was at the polling site, not in retrospect, regardless of what they say on social media.
Thank you, Mr. Wester. Would you like to rebuttal?
Please, thank you very much. Just quickly, in terms of the ability to challenge the voter, you'll see that the social media comments about not voting or voting for Mr. Deary did not come about until after the election. There was no opportunity for us or anybody to really challenge this voter. And you know, it's not disenfranchising somebody who is not legally a Republican voter in a Republican primary. In terms of evidence and hearsay, I mean, as Mr. Norris has already said, the evidentiary rules don't apply to this proceeding. And the reason for that is that it's difficult in the short amount of time that a recount proceeding exists to acquire that evidence. And I'll remind the court of the Pavey versus Pastor case, where the court disqualified a lot of absentee ballots, and it wasn't an Indiana Recount Commission case, but it went to the Supreme Court, and the Supreme Court approved the disqualification of ballots that it felt were invalid, and some of them for many of the same reasons they're presented today, but for others because the votes were considered fraudulent votes. We don't consider this to be a fraudulent vote from the standpoint of did he intend to commit a fraud, but he did intend to vote in the Republican primary, which he wasn't qualified to do. And for that reason, his vote shouldn't count. Thank you.
Thank you.
Just briefly, and PBB Fast Track, that case was completely different and voted, and you know this, it involved ballot harvesting and all kinds of fraud from the region. It's not someone posting something on social media and then in retrospect saying, oh, well, that person posted this, let's go see if we can find their ballot somewhere and then toss it out based on something said not under oath. That who cares what someone said? That still doesn't prove anything. And why I say hearsay, well aware of the rules of this commission, is because the preponderance upon this commission to toss a vote has to be conclusive, not just presumptive. It's conclusive. So you don't have that information in order to give you the authority to remove someone's ballot because they said they voted for the other side and they're a different party. That's just not legitimate or legal or sound, and it's unprecedented. And we will be doing lots of these going forward if that's what we're going to go down the road with some of these cases.
Thank you, Mr. Wester. Commissioners,
Mr. Chairman,
questions, comments?
I don't want to refer to this as his ballot, as has been said. This is a ballot, and it is not tied to anything. It's not defective on its face. There is a challenge process. There are methods for challenging for fraud. This is not fraud. This is avoiding the weird ass process we have for eliminating people from, pardon my French, from primaries. I'm going to move that we count this ballot.
Before we move on, Commissioner Mott.
Just very briefly, Mr. Chairman, I am sympathetic to petitioner's position. I don't, after reviewing the materials, to believe that the social media post reached the burden to remove the ballot and pull it out of the tally. Unfortunately, I think that could have been, how do I put this? We could have had more definitive results had we actually allowed a 30-minute deposition of this voter to occur. And, if it is the same individual, I'm assuming it is. I don't know if it is or it isn't. If he's so proud to make the statements that he intentionally crossed over just to manipulate results, if he was so proud of it that he made those statements on social media, I don't know why he wouldn't make those statements under oath in the deposition. But this commission deprived through a vote them that opportunity. And I guess there maybe there's other means, maybe there's not to meet the burden of proof that I think would be necessary. But I'll be voting to allow this vote to stand.
Do we have a motion to accept the ballot?
I move that we accept the ballot.
I second it. Those in favor say aye. Aye. Those opposed? The ayes have it.
Thank you. For the record, we will show that Exhibit 33, which was a vote for Senator Deary in Liberty Precinct, has been accepted by the commission. And I believe that in Warren County that that Senator Deary had one dispute, Exhibit 1.
Yes, one moment, please. In your, I believe you have, the ballots, if you want to show, it's, Exhibit 1.
So commissioners, before we get started here, this is Exhibit 1, which was a vote that was cast for candidate Copenhagen in Jordan Precinct within Warren County. And I'm going to just make sure that the parties can see that this is the original.
So as you can see, the ballot doesn't contain the required initials, not even one set of initials, which is required under statute. I know it's an in-person ballot, but they still have to be signed by poll workers. Typically, if there's one, it's been deemed okay, it's the intent of the voter. This one has none. So I don't know how we, going back to council's argument about the validity and the trifecta of tests and of blood types and social security numbers that we're going to have to do to figure out people's ballots. How can we count a ballot that has nothing? It's not been, it was not initialed by anybody whatsoever at the polling site, and therefore it should not be counted.
Is in precinct, not early voting.
Thank you, Mr. Wester.
So if I could respond, is that appropriate?
Please, go ahead, Mr. Crowe.
This is not an absentee ballot, as we can see from the declaration of Michelle Hedrick that we provided under tab 9. Rather, this ballot is an election day ballot. It states on it, to cast your ballot, you must take this record to the separate scanning station and scan it. So that's on that ballot. So we know for sure that it is an election day ballot. And I think that Mr. Wester conceded that. Obviously, she has said that there is a requirement for no seal, no signature, no poll, that there's a requirement of seal, signature, and poll clerk initials on an election day ballot. But she hasn't cited you a statute, and she hasn't explained what voting system was used in this county to even establish that with respect to the Vermilion County system, that there was even such a requirement. But even if she had done that.
This is Warren County, by the way.
Oh, you're right. In Warren County. Apologies. Even had she done that, the absentee ballots are held to a much higher standard, as we've been discussing, than our election day ballots, because of the fact that, as the Supreme Court said in Horseman, election day is a closed environment. And so there's no question that this is an election day ballot that was voted on election day. And for those reasons, this, even if Ms. Wester had showed you that this ballot doesn't meet the statutory requirement, which she hasn't done yet, even if she had shown you that, pursuant to 3-1-12-1, this ballot should be counted as an election day ballot. I will also point out that in terms of the signature requirement, Deborah Hyatt, the Warren County clerk, is a Republican who's running for re-election. So there was not a requirement that there be a signature by her on the ballot. And again, she hasn't shown you that there was a requirement that there be a seal or initials on this ballot. And which there are some voting systems in the state that don't require those things for election day ballot. Thank you.
Thank you, Mr. Bulk.
Okay, yeah, so under 3-12-112, it clearly says that it's required two initials. And in other statutes, it says the clerk is also supposed to stamp a line for those initials. I wonder if we should start tossing all the ballots that don't have those on them as well. Might be looking into that. But this ballot, yeah, you're right, it's a closed day, election day. So was the early vote that was just tossed earlier for lacking a clerk signature. This has 0 initials on it whatsoever. No one can validate who gave this ballot, when it was given, who was working, because it's not validated by anybody. Therefore, it is invalid.
To respond. So first of all, 3-12-112 does not contain a initials requirement for election day ballots. So that was inaccurate. Secondly, electronic voting systems do not require, and there's a statutory definition for them, They do not require the seal, the initials, or the signature. So on election day ballots, on an electronic voting system in Indiana, those things aren't required. She has to show you the statute that says that that's even a requirement for an election day ballot. But even if it is a requirement, because it's a closed system on election day, this ballot can and should be counted, because these are not necessary reliability indicators with respect to election day ballots, while they are for absentee ballots.
Thank you, Mr. Bob. Yes, Commissioner Plato.
I heartily disagree. It's my understanding the clerk initials are required even in in-person voting, but it is not an absentee ballot. Therefore, we have the discretion to waive errors by election officials. And I would move that we count this ballot.
Any other questions or comments from the commissioners?
None for me.
We have a motion to count the ballot. I second it. All those in favor say aye. Aye. All those opposed say nay. The ayes have it.
All right, so we will show that that ballot will be accepted by the commission as a vote for candidate Copenhaver in Jordan precinct within Warren County.
Thank you, Mr. Norris.
Yes. At this time, I believe that, let me confer with Deputy State Examiner Gouger real quick, and let's
Sure.
make sure that we have our numbers. I'll provide a very quick update on the Warren County, because I believe that's all the disputes in Warren County if the parties want to get ready for the next county.
Get 'em flow.
Yeah. Okay, well, we're gonna,
Yeah.
I think we'll go ahead and move on without the slides, because
I have conferred, Mr. Secretary, I have the update on Warren County. As sent to the Indiana Election Division, the certified results for Warren County were for candidate Copenhaver, 719 votes, for candidate Deary, 502 votes. The adjusted total after this commission's rulings are candidate Copenhaver, 719 votes, candidate Deary, 500 votes. And now I believe we'll proceed to Vermilion County.
yeah, they'll just go on. Thank you so much. I'm gonna just do this one without slides, because I've had a little issue with the power. So in relation to Vermilion County, there's a downloadable public record available at on the Secretary of State's website that lists the voting systems in use in Indiana. Microvote is the voting system in use in Vermilion County according to that public record. Additionally, we've provided you the declaration of Tammy Lowry, the clerk in Vermilion County, under tab 11 of the petitioner's exhibit binder. And this declaration from the clerk contains 10 paragraphs and confirms that Vermilion County exhibits 1 and 2 which are the two ballots disputed in this county by petitioner, are mailed absentee ballots. We know that these are absentee ballots because of the voting system, as I mentioned, that was in use in Vermilion County. And both of these exhibits have been voted for candidate Geary. If you look at tab 3 of the binder that we provided, you can see these ballots. Exhibits 1 and 2, and you will see that these mailed absentee ballots are lacking the signature of the Vermilion County Clerk. So for the reasons that we've argued in relation to Montgomery County and the actions already taken on the basis of the actions already taken in Montgomery County to be consistent, we'd ask that the commission find that exhibits 1 and 2 in Vermilion County are not showing the required indicators of reliability that are required for mailed absentee ballots, which includes the signature of the county clerk, and therefore these 2 ballots in Vermilion County should not be counted. Thank you.
Thank you, Mr. Brock. Ms. The West.
Yes. These are, I believe, State Board of Accounts has them marked. But what Mr. Bach didn't also show is that what sleeve or ballot went out with these. Under statute, it says the ballot can be stamped itself. There's a ballot that goes out with these. It's not just a Scantron sent. So they possibly put their signature on that. Outside of that, everything is legitimate on this ballot. There are initials, there's a clerk stamp. I don't know if her signature is on that. That's not marked or part of his argument. Nor should it be a reason to disenfranchise people because a clerk signature is missing on something when everything else is there. So I would ask that he has not met the burden to toss another 2 votes because a clerk did not have a stamped signature on a ballot. Also, I note her affidavit, and I don't know why we need an affidavit to tell us what is what and who uses what systems. I'm aware of it because I was in all 6 counties. I am concerned that they had a government official sign a legal document without legal representation there. Every single government employee is represented by counsel. To have someone sign something who's not a lawyer concerns me greatly, especially over tossing people's ballots. So I would ask that these be maintained, these not be rejected. They've not met the burden. Whatever sleeves go out with microvote absentee ballots, that's what the vendor does. The clerk could have stamped all of those with the signature that's missing.
Thank you, Mr. West. From Mr. Norris.
Yes, Commissioners, if it would help, I have the ballots in hand, both exhibits 1 and 2, which were valid votes that were cast for candidate Senator Deary, and would present these to the commission if they'd like to review them.
Do you have the sleeve as well, or just the ballots?
We do not. We only have the what was marked by the party. So I'm happy to present this to the commission.
Jennifer, do you know if there was a sleeve with the materials?
It's exhibit 1.
Was able to review?
I'm aware.
Tell you that almost every mail-in ballot did have a sleeve or an envelope.
Okay.
Given the comments about the sleeve, including by Jennifer from State Board of Accounts, I just wonder if I could address that issue.
Maybe wait a second.
Sure. And I want to just remind the commission that the sleeve really wouldn't show you anything in terms of the 3 required reliability indicators, because the concern and the reason that these reliability indicators of the seal, the signature, and the initials need to be on mailed absentee ballots is the concern that those ballots can be accessed by a family member or by somebody else before they get back and are voted. And the way that you determine that you've got a valid, authentic ballot that you can rely on is that all those criteria are on that ballot. If anyone is missing, then it impugns the legitimacy of the ballot, because it makes it easier to fabricate a ballot. And did somebody fabricate? We don't know. What we know is that the legislature set forward these 3 mandatory criteria in order to protect the integrity of absentee ballots. So I just wanted to make that point about what the absentee ballot sleeve says is not relevant to the reasons that the reliability criteria exist and need to be on mailed absentee ballots.
The signature requirement by a clerk is not mandatory. It literally is not in the code that says absentee ballots shall be rejected. If the General Assembly wanted it to be mandatory, they would have made it mandatory. And they didn't, right? So the absentee ballot goes out as one package, and it says it should be stamped on the ballot card, etc. That's gone out. None of that is shown to you except for a ballot, right? I don't know if the signature exists on the other things. That's not been shown or proven. And again, I would urge you not to reject these ballots. There's no reason to reject them. They're valid ballots that have been counted.
Thank you, Mr. Wester. Any questions or comments from the commission?
Mr. Chairman, as me being consistent, I would move that we accept these ballots.
Do we have a second?
No.
Do we have a motion?
I would, me being consistent, I would move that I motion that we reject these ballots for lack of signature.
I second it. Do we have all in favor, say aye?
Aye.
Aye. Those in favor, say nay? Nay. Opposed? Oh, opposed. Yeah. 2-1, the ayes have it.
Okay, we will show then that in Vermilion County, Exhibit 1 within the Eugene precinct, which was a vote for candidate or to Senator Deary, has been rejected by the commission, vote 2-1. We'll also show that in Vermilion County, Exhibit 2, which was within the precinct of Dana, which was a vote for candidate Deary, has been rejected by the commission. Give me 1 second, I will adjust the totals. Will show that in Vermilion County, that the certified election results showed 902 votes for candidate Copenhaver and 769 votes for candidate Deary. Following this morning's hearing regarding Vermilion County, I showed that the adjusted total is 902 votes for candidate Copenhaver, 767 votes for candidate Deary.
Mr. Norris? Let's.
Yes, I believe. Oh, I apologize. We can move on to Tippecanoe County. That's done with Vermilion.
So in Tippecanoe County, the petitioner will be asking the commission to invalidate Exhibit 20, which should be found under tab 4 of the petitioner's binder, as well as one of the additional 3 absentee ballots that was counted in Wabash 24. And this goes to the issue that I alluded to in our opening regarding misconduct. And I want to describe what happened that we, at least insofar as we know it, in Tippecanoe County. And I would note that regarding what I'm going to say, we have a declaration of Sarah Pfister regarding Tippecanoe County matters, and it details what Ms. Pfister observed when she was on the ground in the Tippecanoe County Government Building, where all the election materials were counted in June of this year. She was a witness to the statements made by one of the employees on behalf of Tippecanoe County Clerk's Office. But you'll remember that we asked for a subpoena to have a deposition with the county clerk because of concern regarding a mailed absentee vote that was acknowledged to be a mailed absentee by the clerk, and how the circumstances regarding how that vote was added on the day after Election Day. And so I'm going to just show you a few documents that have been authenticated in Ms. Pfister's declaration, and provide some explanation of what happened in Tippecanoe County. So these are the minutes of the Election Day meeting of the Tippecanoe County Election Board. And the meeting that was held on the evening of the 5th of May said that there are 5 absentee ballots were delivered to vote centers and will be counted in the morning. All other absentee ballots have been duly processed. Okay. And keep in mind that and I'll explain how, but we know for an absolute certainty that the additional vote that was added the day after the election was added in Wabash 24, one of the precincts in Tippecanoe County and Senate District 23. And this statement by the election board is that all other absentee ballots in the county have been processed. Here, I think that some of the things that I said about concerns that we had about the Tippecanoe election prompted the Tippecanoe County Clerk the very day after the July 28th meeting of the of this commission to go and make statements in the Tippecanoe County Election Board meeting that was held the very next day on July 29th. And the clerk's statements we had transcribed. They're attached to the declaration of Sarah Pfister, and they are a public record because those the meetings of the Tippecanoe County Election Board are put on Facebook, the official Facebook feed of the Tippecanoe County. And so the commission can go online and see those same statements today. They're official public records, and we had them transcribed so that you could see that these same statements that were in this press release that were put out by the county clerk were made on the record in an official meeting. So I'll just refer kind of to the highlighting here, referring to the absentee ballot in question, and that is the ballot that is alleged to have come in on the day after the election and been voted. Regarding the absentee ballot in question, Roush stated, the ballot referenced in the recent allegations was never unsecured and was never outside the custody of authorized election officials. At all times, it remained under the supervision of a bipartisan team following established Indiana law and the procedures adopted by the Tippecanoe County Election Board. And then going on, the Tippecanoe County Election Board authorizes the Republican and Democrat poll workers supervising vote centers to transport absentee ballots received by 6 p.m. on election day to the receiving team located on the second floor of the county building. And then she goes on and says, to address the specific handling of the ballot in question, again, it's the ballot that resulted in a new vote for candidate Deary the day after the election. Roush noted, on the night of the primary election, 4 absentee ballots were received through this process. The following morning, before tabulation began, the ballot envelopes were opened in accordance with Indiana law. This has been our standard procedure since Indiana law changed the absentee ballot receipt deadline from noon to 6 p.m. on election day. The tabulation is also under voters surveillance or video surveillance. So she confirmed what we alleged that the county had been saying that there was a new vote. It was a absentee ballot that came into a vote center on election day. Okay. And that is their explanation of why a new vote was added the day after the election. And, you know, a lot of people might have just accepted that, except that we asked for all of the absentee ballot envelopes to be made available to us. And we're making these 3 absentee ballot envelopes from Wabash 24 exhibits in this proceeding. And you can find them under tab 5 of our submission.
Council, can we move from this, please? This identifiable information.
Yes, we can. These absentee ballots were received and they are stamped, and the commission can examine the stamps. They were received on April the 8th, April 20th, and April 22nd. So the claim is that a new ballot from Wabash 24 came in at a vote center on election day, May 5th. But the evidence from the absentee ballot envelopes establishes that no ballots in Wabash 24 came in on election day. Those ballots came in on April 8th, April 20th, and April 22nd. And the documents that you have in front of you confirm that. So why have we been told something that is evidently not true about an absentee ballot? Why was the explanation that there was a new absentee ballot given to really the world when we raise these questions about what happened and where this ballot came from? Now, we can identify that the ballot that was added because we also received, and it's all laid out in Ms. Pfister's declaration, we received the detailed vote totals printouts of what happened on election night. And we were told that the new vote came in Wabash 24 when we were in the county. But we verified it by having all of the data that showed what votes came in the day after the election. And that's what this chart demonstrates. It demonstrates who received votes from the ballot that came in on and was counted for the first time on the day of the election. And remember, the election board minutes from May 5th say that there were no other absentee ballot issues. They were all cleared up by May 5th. And but yet there are 3 envelopes that show absentee ballots came in April, and somehow there was a new vote that occurred in Wabash 24, despite the fact that all of the Wabash 24 absentees had been in for weeks. And so this is the ballot. These votes are the votes that the electronic records show were added to the various candidates on the day after the election. One of the votes went to Senator Deary, which we know because his total went up. One of them went to the Circuit County Clerk, Julie Roush, and 8 other people. There is only one ballot in Wabash 24, and it's Exhibit 20, that has 10 candidates voted for. So this ballot should not be counted at a minimum in this county, because it's a mailed absentee ballot regarding which the authenticity and the explanation in the public records are entirely inconsistent and not credible. Why this happened, I can't tell you. All I can tell you is that on the record, the Tippecanoe County Clerk is absolutely inconsistent in her statements with what the official records show. And you have that information all before you with the attachment to the attachments to this declaration of Ms. Husner. Now, there is another issue in Wabash 24. And that is, there is a declaration or a notice in the materials of, and this is at the very back of all of the documents that are attached to the Pfister Declaration. It's a notice to absentee voter of mismatched signature on absentee ballot security envelope and signature verification affidavit. This signature verification affidavit is completed, and a ballot must have been voted because there were three security envelopes and 3 absentee ballots voted in Wabash 24. But this signature verification affidavit was never processed as it's required to be processed pursuant to the Indiana Code. What is required to happen when there's a signature verification affidavit is that affidavit gets sent back to the address of the voter, and they're required to sign the affidavit. And then the next step is that the county election board has to compare the signature on the affidavit to the signature that was on the back of the absentee ballot envelope. That never happened. And we know it because we have the minutes of the meetings, and they're attached again to Ms. Pfister's declaration. We have the minutes of the election board meetings, and Ms. Pfister has reviewed the video of those meetings. And there's, number one, no record of the mismatched signature affidavit ever being considered by the election board or verified in Tippecanoe County. That's number one. Number two, I showed you how the minutes of their meeting on election evening said that all issues related to mismatched signatures all issues related to absentee ballots have been cleared up by election evening. So that but just for sake of completeness, we also viewed the May 15th meeting of the election board, which is where provisional ballots were considered, which would have been the last opportunity to kind of cure or at least address a mismatched signature verification, and that was not addressed in that meeting. Now, again, these are mailed absentees where statutory processes were not followed. Ms. Pfister's declaration sets out the statutes which needed to be followed. And particularly with respect to the mismatched signature affidavit, that statute is, forgive me, 3-11.5-4-13.5. And it sets out the process that I just described. Paragraph 62 of her declaration says, if a signature verification affidavit is timely returned, then the election board must, quote, compare the signature on the verification statement with the signature on the affidavit of the ballot envelope. And if the county election board determines that the signature on the affidavit on the ballot envelope and the signature on the verification affidavit match, then the ballot may be counted. Here, that verification process was not completed, yet the results from precinct 24 suggest that the ballot was counted anyway, which is a huge problem. It's and if you want to take a look at the signatures, and I'm not asking you to be handwriting experts, but the signatures don't match from the absentee ballot envelope as compared to the signature verification affidavit. They pretty clearly don't match. So, but in any case, we know that from the records of the Tippecanoe County Election Board that they didn't even complete that statutorily required process. So for those reasons, there has been misconduct related to the handling of absentee ballots in Tippecanoe County. All these issues relate to Wabash 24. And in Wabash 24, there were 3 absentee ballots that were counted, and they all had a vote for candidate Deary. And so one of them we showed you is the one that was counted the day after the election, which didn't have a valid explanation. And we can pick that ballot out because it's the only one that had 10 selections. That's Exhibit 20. But we think at least 2 votes should be removed from candidate Deary's total because of these pretty gross and bad failures to follow the requirements related to absentee ballots. Thank you.
I won't ask one.
Thank you, Mr. Bro. Commissioner?
Just one quick question, Mr. Bach. Like when you say misconduct, I think you alluded to this at the end. When you say misconduct, do you have an opinion if it's intentional or unintentional or both?
And I appreciate you bringing that up because I needed to make that distinction. There's fraud, tampering are the first part of the inquiry, we're not alleging that there was fraud or tampering. We don't know. But we are alleging that the explanation given was not accurate. And it's on a high profile issue where a recount's going on, and we didn't get an accurate explanation on the record from the Tippecanoe County Clerk, and she needs to answer to that, and she can provide an explanation, and perhaps there's an explanation that doesn't have anything to do with anything other than she wasn't being truthful, but it's clear that she's not corroborated by the records. So the ballot handling issues we categorize under misconduct, which would be lesser than fraud or tampering.
Thank you.
Thank you.
Any other questions?
Can I ask one clarifying question? Originally, we brought up that you were discussing exhibit 20, and then in reference here, you could reference exhibits 21 and 22 as well.
Yeah, those are the other absentee ballots and within Wabash 24. And we don't know which of those were in which envelopes. We don't know which absentee ballot envelope went with which vote. But
Are you grouping those together? That's what I'm asking.
yes, we're asking that they all be considered together. Yes, thank you. And that 2 of the votes be removed.
Thank you, Mr. Bog. If commissioners have no other questions or comments, Mr. Wester.
Yeah, I'm still confused by the election super sleuth presentation here. I don't understand how we can seemingly remove 2 votes, valid votes, from someone based on what they think occurred. To this day, I don't believe they've even spoken to the Tippecanoe County Clerk by a phone call, anything. Why would you not start there as opposed to meeting minutes and then spending probably countless hours trying to figure out what ballot did or did not come in? Obviously she's made public statements in public meetings. These ballots have been counted. To go back and say, we need to figure out this application for one that the signatures don't match, and then possibly another one that came in on a different date. I don't know the answers to that. This is what recounts do. Things happened, and if they were told by someone that it was Wabash 24, they could have been mistaken. That's all hearsay. I don't know who they spoke to. They didn't talk to the clerk. So I don't know what occurred. These are actual valid ballots that you will be taking away from a voter based on what they want you to believe occurred. None of that is required of this commission. To take away votes, they were validly voted. Okay, so if sue Tippecanoe County, I guess. If something wasn't done procedurally, and let's just be mindful, there's one application that the signatures didn't match. This is not some big line of fraud where there are 500 that didn't match, or all of these. This is ticky-tacky stuff that they're wanting you to toss people's ballots on. This is not about getting to the bottom of elections and seeing who a valid winner is. It's being ticky-tacky and throwing votes out based on what they want you to believe. I don't know why a vote, or what the clerk has said is that a ballot came in to a vote center. That was their original argument. You couldn't do that. But then I told them that they had adopted a plan where you can drop off absentee ballots at a vote center under Tippecanoe County's vote center plan. Now it's shifted to this might have come in earlier. I don't know when it came in. I'm not the clerk, and it's a valid vote. The ballots are valid. Everything is valid besides what they want you to believe is some boogie monster somehow snuck up to Tippecanoe County, and these 2 votes are the end all be all of this election. There's no reason they should be tossed, and I ask that their request be rejected.
Just
Would you like to rebuttal?
Please. Our position hasn't changed, and we did brief this issue related to ballots dropped off at a vote center. That is illegal under Indiana law. Just as our brief said, you can't drop off a ballot at a vote center on election day and have that ballot count. And the Indiana statutes related to the handling of the ballots provide that is not a valid way to receive a ballot. Whether Tippecanoe County does that, and I think I watched one of their meetings where they approved that sort of a process for election day, and they're just flat out wrong regarding what they're allowed to do. That's why there is a Indiana home rule statute, which you can pick that home rule statute 3-5, whatever that says that was adopted by the General Assembly in 2023 and provides that in terms of elections that the counties don't have home rule authority, and unless if there's anything related to the procedure related to elections, the counties have to follow the election code. And only if a procedure is explicitly endorsed, which voting at vote centers with absentee ballots on election day is not, only if it's specifically endorsed under the the home rule statute as amended in 2023, can voting procedures be changed. So we haven't backed off that argument. And the last point that I'll make with respect to these ballots, Exhibit 20 is the vote that was in the ballot that was counted the day after Election Day. The explanation for that, as we've demonstrated, is completely inaccurate. So when I said in response to Mr. Norris's comment, are we grouping them together? I think we want to separate 20 and have consideration on 20. And we're asking for Exhibit 20, the ballot that came in the night after the election, to be excluded. And then one of the ballots in the grouping of 21 and 22, which are the two other ballots remaining in Wabash. One of those votes for Deary should also be removed. And that's because of the mismatched signature issue that was never addressed by the Marion County or the Tippecanoe County Election Board.
How do we know that it was a vote for Deary based on an application for an absentee ballot? I'm confused. And there is in code where the counsel for the commission, I assume, can educate the commission about vote centers or election boards, county election boards, adopting policies. This is all from instruction from the Secretary of State's office. They can adopt procedures regarding vote centers and absentee ballots. And if there are the applicable individuals there, they can accept absentee ballots, which is what occurred here. Now, as it relates to an absentee ballot application where signatures don't match, how do we just are going to willy-nilly pick a ballot and say it must be that one that we remove? And I'm confused by that. I don't know what the clerk did or did not do, but it's not our role here to remove votes based on something that wasn't acted upon. Now we're going to punish the voter. No one at the polling site, to my knowledge, told the voter to take their ballot back or invalidate it, or any other process that could be done that is educated to election workers. So the voter shouldn't have to pay, just like in all the other examples. It should have been caught. It was not, by the election board or election workers, and the voter given an opportunity to fix their ballot, but that wasn't an option for them. So the voter is the one that has to pay. That doesn't make sense. That's not what the law says. And they should not be allowed to just toss two ballots out based on their explanation of what they think happened.
Can I have the site to the home rule amendment in 2023, which was Public Law 4 in 2023. It's 36-1-3-8A12. And it says the county does not have the power to, quote, conduct an election except as expressly granted by statute. And that change in the home rule statute was expressly adopted to address situations like this, where counties were trying to adopt essentially, ballot drop-off locations on election day for absentee ballots. The statements regarding how an absentee ballot can be voted, a mailed absentee ballot, are inaccurate. There are three ways, and our prior brief made this clear. Number one is it can be mailed in to the clerk's office. Number two, it can be brought in and deposited at the clerk's office. Or number three, it can be deposited before election day at a satellite office of the clerk's office. And those are the three ways in which a mailed absentee ballot can be voted. There's no provision for voting it on election day, and there's no provision that says it can be voted at a vote center. Tippecanoe County says that they can, but they can't. And again, that's another one of the situations where when an absentee voter avails themselves of the opportunity to vote absentee, there are other additional requirements that they need to follow in order to protect the integrity of the ballot, make sure that we aren't disenfranchising people that follow the rules by trying to get ballots in the system in a way that's not provided by statute. They are instructed on how to vote absentee ballots. In this case, whatever ballot that got you these results were, according to the clerk, and what I've shown you, her statement that was made to the election board was that that was dropped off at a vote center. Now, that's inconsistent with the documents. So if it is as the clerk said, that is another reason, because it's inconsistent with code on how the absentee ballot can be voted and returned to the clerk, that Exhibit 20 should be found to be invalid. Thank you.
But again, we don't know. And under Indiana code, again, I'll redirect everyone back to the rejection of absentee ballot statutes. Nothing that he just mentioned is in that statute regarding you shall reject if X. So we don't even know what ballots, where they're presuming they think they've tracked it down, but they don't know. So what they're asking you to do is guess and assume that both of these are Deary ballots based on a signature issue and an absentee ballot because the number went up, and then you guys figure out which ballot it is and then just reject it. That's not the way election law works. That's not the way the voters want you to have our system work. It's not fair. What's being asked of you is not fair. And it should absolutely be rejected to disenfranchise two people that voted that never were given an opportunity to correct anything whatsoever. That's the duty of the election officials. That's a duty of the Secretary of State to train clerks and election officials. Why are we making the voters carry the burden of fixing something that their ballot there might be an issue? If they were not allowed to accept absentee ballots at a vote center under code, it says they can do that. We can disagree on that. Then they should have been told to turn around, return, and go take it to the clerk's office, or void it and vote in person, right? Not just we'll accept it and then everyone goes to sleep thinking, oh, my vote counted, it's great. And now we're trying to have our votes removed from us because they don't like the way it was done. So we can't reject this ballot or the other one based on a signature affidavit issue. That should have been dealt with long ago.
Thank you. Would you like to rebuttal?
I mean, of course you can. If the signatures don't match, it's not a valid vote. It wasn't voted appropriately according to the absentee ballot requirements. So if the signatures don't match, it's absolutely an invalid ballot. So secondly, the idea that we can't identify the ballot, we have identified the ballot. There's only one ballot. There's only 3 ballots in the precinct. All of them were voted for candidate Deary, and there's only one that resulted in 10 votes that were all added to vote totals on the day after the election, and those 10 votes correspond to one of the ballots, the Exhibit 20, that is in Wabash 24. So we know the ballot that was alleged to have been voted at a vote center, and if that allegation is accurate, then it's invalid. If it's not accurate, then you really have to wonder. I mean, where and it doesn't line up with any of the evidence. You really have to wonder about the integrity of that ballot. I mean, there were 3 absentee ballot envelopes The election board said all of those have been addressed. And yet there's a vote that comes in and is added to the total the day after the election, and it's added in Wabash 24. How does that happen? And so that there is a mystery vote that gets added that doesn't correspond to any of the documentation. So I know that we've thrown an awful lot at you. It's kind of the nature of the process that is the case. If there's any question, I would really urge because this is an important issue, I'd really urge the Recount Commission to review the declaration and assure yourselves that we have established that the statutes weren't followed and that these votes aren't reliable and weren't voted reliably.
Thank you, Ms. Brock. Commissioners, questions, comments?
Would you like to see any of the ballots?
Yeah, that would be wise.
We'll pull ballots 20, 21, and 22 for the commission. Wow. You want to continue on while we pull those?
So,
Thank you, Mr. Norris.
yeah, I have a quick question for council, either one of you, but and I think they're in the materials. Were the ballots received before election? All three of these ballots received before election day?
Yes,
And that's file stamped on the
yes.
sleeve?
Otherwise they're rejected. And I don't know if it could have been, an election official dropping them off to be counted at a vote center. We don't know who dropped them off, right?
At the vote center?
Yes.
It is.
I mean, some counties have central count, some counties vote at the polling sites. I don't know. It could have been received somewhere April 6th. But again, that's just them piecing together what they think occurred. Not conclusively what they think occurred.
And councils can please correct me if I'm wrong, which I usually am. But my understanding is if someone mistakenly drops off an absentee at the vote center, that thing has to find its way to the clerk by 6 p.m. or it's done. It is not, dropping off at a vote center is not the way to vote an absentee. It has to go to the proper place. If it goes to the vote center and they have 2 members that can get that to the clerk, fine. If the voter takes it to the clerk, fine. But I don't think it's valid sitting at the vote center at 6:01 p.m.
Yes, Commissioner Clater, that is correct. The law is quite clear. For an absentee ballot to be timely, to be counted, it must be at the county election board by 6 p.m. when the polls close under state law. If it arrives after that time, the law is very specific. The county election board is forbidden from counting it. So it's automatically rejected.
So if in fact this was at the vote center as they're packing up at 6 p.m., it's done.
Based on my reading of the law, I would have to say yes.
Commissioner Salkin, you.
Well, and then to ask a further question, I mean, that's a possibility of what, I mean, that's a realistic possibility of what occurred here.
Absolutely.
Yeah.
But we don't know what ballot's what, to be honest. I mean, they think they know what ballot they're talking about, but so one ballot concerns me. I don't know that we know what ballot that is, but if every absentee in the precinct was voted for one candidate, that means it will be easier.
That is the case, Mr. Clater, and if this is helpful as well, the time of the minutes in adjournment where the county election board on election evening said that the ballots were delivered to vote centers and will be counted in the morning was 8:45 p.m. And I can only so that was this was something that was being done, late in the evening, and it wasn't counted until the next day.
Thank you, Mr. Buck and Ms. DeWester. Mr. Norris, any other additions,
No,
comments?
Mr. Secretary, the only thing I would add to this is that remember that Exhibit 20 appears to be segregated as this ballot that's that at least the petitioner Copenhagen has alleged is the one that was dropped off at the vote center. So Exhibit 20 is separate than Exhibits 21 and 22 for, I think, determination purposes.
Can I ask for just a clarifying? I'm a little bit confused. I want to make sure all the commissioners we're all aligned on this one. The factual allegations that are alleged that particular absentee ballot, it was delivered to the vote center on election day, or was it delivered to a vote center during early voting?
The allegation is that the new additional vote came from a vote center. That's what the county clerk said. The ballot itself, or that was counted in Senate District 23 had 10 votes on it. There's only one of the 3 absentee ballots that have those 10 votes, and those votes match up exactly with the changes in the vote totals for 10 candidates. So we have the ballot. It's Exhibit 20. There's no other possibility that's the ballot that was voted on the day after the election. But I can't tell you if a ballot came in from a vote center. Because I can't accept what the clerk has said, given that her statements are inconsistent with the documents and the records.
But we have 3 envelopes. We have 3 absentees, 3 envelopes dated prior to election that were received. And that just makes your head spin around.
Did ours too.
That doesn't mean it should be rejected, though.
No, I'm saying it.
That is, they admit that it was received far before election day, so there's not an issue. They want you to believe their fact pattern. They don't know for sure. They've never spoken to the clerk about said fact pattern. They're just piecing together public statements and whatnot, right? So they can call the clerk and have a conversation or an explanation, but instead we're just guessing. We're piecing together what we think might have happened and asking you to say, don't count these, please.
I'm just going to object because she keeps saying we could call the clerk. The board the commission needs to know that my legal assistant called the clerk twice and had the phone hung up on her when she said that she was calling on behalf of the Copenhagen team. So that is not an option. That's why we sought a subpoena, and we didn't get a subpoena. This is the best evidence that we have, and it is strong evidence that there's a problem with these absentee ballots in Wabash 24. And we've done the best that we can in a short amount of time with no subpoena authority. We've investigated these records. We've gone back to get the election board minutes and to establish that we have not been told the truth to. And that this ballot has, which they can't get their story right and consistent with the documents, was voted well after election day, and the story doesn't line up. So the absentee ballots are supposed to be handled in a very careful fashion because they are subject to being mishandled and misused. And I think that we've proved that these were at a minimum mishandled, and likely, it certainly counted after election day, which is not appropriate. And so what can I say? But I had to respond to the idea that somehow that we have done less than we should be doing in representing our client, because we have tried to get information from Tippecanoe County.
2 phone calls to a county clerk and not even making connection. I mean, the attorney should have done that, could have done that. Instead, they spent hundreds of hours piecing together something they want you to believe they do not have the factual basis for. There is no conclusive evidence that this is what occurred just because they say it's true. We can't toss ballots based on what their assumptions are. If they wanted to know the facts, I presume they would have gotten to the bottom and known the facts. But it's easier to come in here, throw a bunch of garbly-gook at you guys and expect you to say, yes, we need to get rid of this one ballot. If there was misconduct, and it's offensive to say that someone committed misconduct because of a signature affidavit, it's a mistake. People that work the polls make mistakes. They're human beings. And the 3 envelopes that he shows were all received well before Election Day. So I don't know what occurred. I don't know where a vote changed. I don't know. But that doesn't give you leverage and or the authority legally to say you guys should just discount 2 different ballots. Pick them.
Thank you both. I think at this time, I would like to make a motion to accept the ballot based because there are 3, not just 1, there are 3.
To
Do we have?
accept them the way the Board of Accounts counted them as valid ballots. I will
Yes.
second that.
May I have 30 seconds to speak with
Please.
council?
Mr. Claytor, can I just correct just one statement of that?
Sure.
The 3 votes that's certified by the county election board and the election division. You said the SBOA. I just want to make sure that we're.
I believe the SBO
They
counted them
matched.
as valid
Yeah.
ballots.
Yes.
So that's, yeah, that is a good correction.
I apologize.
Did I hear we have a second?
I'm sorry?
Did you second it?
Yes.
All in favor, say aye.
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 All opposed, say nay. The ayes have it. Mr. Norris?
Okay, thank you. For the record, we will show that exhibits 20, 21, and 22 all were votes for Senator Deary will be accepted by the commission in Wabash 24. With that, Mr. Secretary, before we proceed, I mean, it is 12:15 very quickly. I don't know if the commission wanted to maybe take a quick restroom break and proceed, or we hadn't really discussed what to do with this. We can take an elongated break to give maybe people an opportunity to grab food as well. I leave that up to the commission, or I'm ready to proceed forward as well.
It's up to everybody else.
I was
Good.
I would suggest a short 5-minute break.
Perfect.
So 5-minute break, 5 minutes.
Let's take 5 minutes. We'll return at 12:25. Thank you.
You call that now? That's why I'm a lawyer.
I guess we should go wait later. Sure. Yeah, my hands are a little tied. I don't have a lot to say.
I got it.
Yeah. So in your yes. Yeah, that was what they did to us. Yeah, you want to follow up. You should have came in early today.
Escape while you can.
That's right, that's right. Or snack while you can.
Well, yeah, that's valid as well.
Yeah.
You want to take that purpose or no? You're just. One of the great, I'll down and work here. You're rough,
Ready?
Okay, thank you all. So we're gonna muscle through this real quick and hand it over to Mr. Norris and see what's the next step.
Yes, thank you, Mr. Secretary. We were still in Tippecanoe County. Were those all the disputes for petitioner?
Yes.
Okay. Senator Deary, Samantha, do you have, Ms. Wester, do you have anything in Tippecanoe County?
Let me double check.
We have, exhibit 1. She's got one.
What's that?
I apologize. I just want to make sure. So exhibit 1, which is Shelby 2. I believe both parties have withdrawn those objections.
That's right.
That's right. Thank you. I apologize, commissioners. That will suffice then for Tippecanoe County with no other disputes. I understand candidate Copenhagen had various other ones, but I'm assuming then at this point that those are being dropped.
They're being
Withdrawn.
based on prior rules.
Okay, thank you. So with that, commissioners, I will report that the certified results will stand as follows. Candidate Copenhagen, 1,104 votes. Candidate Deary, 2,136 votes in Tippecanoe County, and no adjustments based upon this commission's rulings and the statements of the parties. Thank you. Now we'll move on to Park County.
Thank you. Mr. Bob.
Yes, and Mr. Chairman, we're going to withdraw our objection to the provisional ballot. We had an argument, you may recall, we kind of argued about this at the last hearing. So we've decided to withdraw that argument. We've taken a closer look at the ballot, and we think the right decision was made on this ballot.
Thank you.
Thank you. With that was in Park County, Mr. Secretary, that was the only dispute. I believe Senator Deary did not have any disputes as well in Park County. So I will go ahead then, and with that, the certified election results will stand. In Park County, candidate Copenhagen had 1,249 votes. Candidate Deary had 1,191 votes. And with no adjustments by this commission, those results will stand. Thank you.
Thank you.
Now we have Fountain County.
In Fountain County, the petitioner would like to proceed to exhibit 121, which is in precinct Logan 2.
Precinct, or excuse me, you said exhibit 121?
Yes.
Give me 1 second, please. I want to make sure I find it so I can follow along.
Absolutely.
Will you be showing this one on the screen?
Yes.
Okay. With that, go ahead and proceed.
Okay. Yeah, we're showing it on the screen, and it's also in our exhibits. You want to look more closely at the ballot, under tab 7. It's about in Logan 2, and Here it is on the screen. This is a provisional ballot. So this is the first provisional that I think we've raised questions regarding. The concerns we have with this ballot are the lack of a the lack of the initialing. And I'll show you the reason why we're concerned about that. There's a specific provisional ballot statute that says if any ballot cast by a provisional voter does not contain the initials of the poll clerks, the ballot shall, without being unfolded to disclose how the ballot is marked, be endorsed with the word rejected. And so this ballot should have been rejected. And so because of the failure to reject this ballot as provided in 3-11.7-5-5, we asked that this ballot not be counted.
Ms. Wester?
Thank you. So I understand what the provisions and whatnot. So someone goes into a polling site and is given a provisional ballot, presumably by the election clerks who don't initial it. The election board then votes to count that. So we've gotten two sets of individuals that have looked at it. The person shows an ID because they're voting in person. And so because of the failure of the election individuals to initial anything, should not be at the harm to the voters. Under code, it states that a ballot should not be tossed because an in-person ballot should not be tossed simply because the failure of an election official to act outside any other evidence of fraud, misconduct, tampering, that kind of stuff. So someone clearly went in, showed their ID, signed a poll book, did all the stuff. They were given a provisional ballot for whatever reason. It was subsequently counted later by the full election board. So there is no reason, there is no authority that gives you guys the ability to toss an in-person ballot simply for lack of initials by the very people that were handing the provisional ballot and cause those individuals to trigger that person to issue a provisional ballot. So this ballot should absolutely not be rejected.
Thank you. Questions, comments from the commission?
May I just have a brief rebuttal?
Sure.
And I'll make it really short. We've been here a long time. So this statute's very specific in our arguments, the specific controls. It says rejected, that it's shall, without being unfolded, to disclose how the ballot is marked, be endorsed with the word rejected. So thank you.
Commissioner Clayton.
Yeah, Mr. Chairman, it's my belief that under the counting statutes, if it's an absentee ballot, which this is not, we have no discretion. In this, I believe we do have discretion. And for the sake of consistency, till I pass it over to my brother at the other end, I'm going to move that we allow this ballot.
Thank you, Mr. Clayton. Commissioner Morley? Questions?
There's a motion.
Oh, there's no.
There is a motion.
There's a motion. Okay, there's a motion. Do we have a second?
Let me talk to council here for a second.
Do we have a second on the motion that Mr. Commissioner Clayton made?
Not for me.
Since there is no motion on the second, we can make another motion. Is that right, Council?
I would move to reject the ballot based on the statute.
Do we have a second on rejecting the ballot based on the statute?
Yes.
I second it. All in favor, say aye. Aye. All opposed, say nay.
Nay.
The ayes have it, 2-1.
Thank you. We will show that
Exhibit 121, which is a vote counted for Senator Deary within Logan 2, has been rejected by the commission. Any others?
Shameful.
We're gonna withdraw the remaining challenges and ballot.
There any? Have several here listed by Senator Deary.
Yeah, and there are 4 that we have. Is that,
Yes, I compare. You filed several withdrawals.
I have the reading. Those are exhibits. 80, 81, 149, 156. Okay.
81 would be the first exhibit disputed by Senator Deary. Section 6 statement. Even section 6 statement. That word, Mr. Glazer, we're going to use that. Thank you. Yes, so I will go ahead and show. So this is updated. Yes. Okay, so. Great. $81. Well, so we're trying to compare the statement 6 withdrawal list versus the disputes that it has. And so far we found that 81 was not withdrawn and still remains a valid dispute by Senator Deary. Exhibit 81.
Mhm.
That's our records as well.
That was what?
That comports with our records as well.
Okay.
That she's preserved her dispute on exhibit 81.
and I'm going to withdraw that one.
Okay. We'll show 81 is withdrawn. 156, 149.
Which ballot?
156.
156?
Yes.
Okay. Logan one.
I assume you handed him 156, Mr. Norris?
Yes, ma'am.
Okay. So what you've been handed is a ballot from Fountain County. Recognize it's an in-person ballot, but it has no initials on it from anybody at the polling site, which is required, as we've discussed ad nauseum, under code to have initials on the ballot or in person. I know council said that that is not correct, but it is. Under 312-112. All right. Yep. So I know that absentee ballots are the hard and fast, and there's discretion on in person. This one has none. And I know that we've discussed these previously, and it was counted, but I'm asking that this one not be counted.
Thank you, Mr. Wester.
And then just to reiterate, this is a election day ballot in-person election day ballot.
And it's still required to have initial.
Yeah.
That's correct.
So
Under 312-112. Applies to any votes cast by any method.
Couple of things. One is, this is identical to the Exhibit 1 in Warren County, Jordan precinct, which uses the exact same voting method as in Fountain County. They have the same, to cast your ballot, you must take this record to the separate scanning station and scan it. It's the same ballot. That this panel, this commission unanimously voted because it is an election day ballot. So and here's the statute, 311-10-26.2, electronic voting systems. I mean, there's a definition for that, but they aren't required to bear a seal, signature, or initials for the election day ballots. So that you have to tie the voting machine to to the statute. And that hasn't been done here. But to be consistent, the commission should count this election day ballot as it did with Warren County ballot exhibit 1, where the commission unanimously approved the ballot, which also didn't have initials or a seal. There was no signature requirement in Fountain County because the clerk was up for re-election.
Thank you, Mr. Brock. Questions, comments?
I don't agree with everything said, but I would like to consistently move that we accept this ballot.
Second.
Do we have a second?
Yes.
All in favor, say aye. Aye. All opposed, say nay. The ayes have it. Mr. Norris.
One second. We will show that exhibit 156, which was a vote for candidate Copenhagen, will be accepted as presented. And I believe the only other exhibit that we have is exhibit 149 for respondent.
Yes. And I'll go ahead and withdraw that. It's an in-person and only one initial, so it's pointless to discuss that if we're accepting them without a.
Show that the dispute for exhibit 149 has been withdrawn. One second while we just make sure that we shut all of our.
Do you want this back?
I will show, I believe that's. So we will finish out Fountain County, and then I might ask the commission if we might take a brief recess while I consult with SBOA on final vote totals here for a second. So I will show then that for Park County, that the certified election results, or excuse me, for Fountain County, I apologize. For Fountain County, the certified election results were for candidate Copenhagen, 1,967, and for candidate Erie, 1,516. The as adjusted total following today's hearing for Fountain County will be candidate Copenhagen, 1,967 votes, candidate Deary, 1,515 votes. And at this time, I'd ask if we take a brief recess for
You may just let us know when you're ready.
return at 1:10 or so,
That sounds good.
15 minutes.
There we go. It should turn on here in a second. Thank you, Mr. Secretary. We will proceed now with segment 6, which is the Recount Director's Report as under section 20B12, whether there were any ballots not presented by either party that are still in dispute. I believe that all the ballots at this point have either been withdrawn or discussed and adjudicated. And if the parties believe there's anything that we may have missed, speak now or forever hold your peace. Not hearing anything. All right. So step 7 here is to adjust, resolve, and certify the election results. As you can see here, the adjusted tally for each county is now shown on your screen by the Indiana Recount Commission. And the adjusted tally now shows that the total results for Senate District 23 as determined by the Indiana Recount Commission are as follows. Candidate Paula Copenhaver, 6,332 votes. Candidate Spencer Deary, 6,329 votes. At this time, I would propose the following motion to be read by one of the commissioners if they so choose.
If you would like to do that.
Sure. Mr. Chairman, I move that we adjust the tally certified by the State Board of Accounts to conform to the determinations made by this commission as follows. Candidate Paula Copenhaver, 6,332. Senator Spencer Deary, 6,329.
Do we have a motion? Do we have a second? Second, all in favor say aye.
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 Aye. All opposed say nay. The ayes have it.
Thank you. Now, at this point in time, I would ask that the commission make a motion to certify these election results.
Mr. Chairman, I will so move.
I'll second.
All in favor say aye. Aye. All opposed say nay. The ayes have it.
Thank you. That concludes the recount and contest. The other matters are if the commission would make a motion to release the impounds in Montgomery, Park, Warren, Vermilion, Tippecanoe, and Fountain counties.
Mr. Norris, is it within one of your slides to have us dismiss the contest?
No, it is
petition?
not in one of my slides at this time.
If you do not mind if I interject, if I would like to move that we dismiss the contest count that was in the petitioner's petition.
I will second that.
All in favor say aye.
Aye.
All opposed say nay. The ayes have it.
Thank you. With that, if the commission would be willing to release the impounds for Montgomery, Park, Warren, Vermilion, Tippecanoe, and Fountain counties. Again, all these exhibits have been saved electronically. And there's paper copies as well, but the impound will release the physical copies of those exhibits.
I'll so move.
Second. Oh, sorry. Second.
All in favor say aye.
Aye.
Aye. All opposed say nay. The ayes have it.
Thank you. One other remaining issue today is the bond, which has been put up by candidate Copenhaver. Candidate Copenhaver has succeeded in her challenge here. So, Mr. Kochever, do you have any guidance on what to do in this particular scenario?
Yes, thank you, Mr. Norris and members of the commission. Per Indiana Code 3-12-11-10, subsection D, it reads, if after a recount it is determined that a petitioner has been nominated or elected, the deposit furnished by that petitioner shall be returned to that petitioner in full. Says Candy Copenhaver has succeeded in her recount and has appeared on the certificate that will be signed by this commission at the end of this meeting to be the nominee for Senate District 23 for the Republican Party. She is entitled to a full refund of her cash deposit that was made to the Indiana Recount Commission, and that should be given back to her as soon as humanly possible.
Do we have a motion?
I so move.
I'll second.
All in favor, say aye.
Aye.
Aye. All opposed, say nay. The ayes have it.
With that, I have no other issues to address at this time, other than ensuring that, that the commissioners remain here to sign any of these orders before we leave today. Thank you.
Thank you, Recount Director Norris. I would like to thank, first of all, the petitioners, the respondent, and their counsels for their representations. Thank you. Thanks to my fellow Recount directors. Thanks to the State Board of Accounts. Thanks to the county clerks, local election administrators. Thanks to the Indiana Election Division staff in my office for their assistance advising the commission and everyone else. And also thanks to our court reporter. Thank you for your hard work. And thanks to the Recount Director, Evan Norris, and his deputy Recount Directors. Thank you all. I believe our 2026 primary election recount proceedings are now complete. May I have a motion to adjourn?
So moved.
Do we have a second?
I'll second that.
All in favor, say aye.
Aye.
All opposed, say nay. The ayes have it. Thank